evening, everyone. We're going to start very shortly, just for your edification, so you don't think we're sitting here doing nothing. We just have to wait on the minority member before we tonight. In terms of comments from committee members, certainly our committee members will be asking questions.
Hang on one second. Can we keep that door shut? We're having trouble hearing in here.
Thank you. Certainly, the committee members may have questions of those testifying or comments. If a question is asked of you, certainly you'll have an opportunity to answer that question. If it's simply a comment, it's not going to become a debate. Again, there are hundreds of people here this evening to testify, so we just want to take that into consideration, that every comment does not become a debate. Senator G has arrived, so we can start. The other, just I guess in terms of process and procedure, because of the amount of people and the amount of people that have signed up on almost every bill, all of the bills on tonight's agenda have to do in one way or another with firearms. We are going to hear them all together. That way I will have the sponsors first give their opportunity to present whatever it is they're looking to present, and then I will go through the sign-up sheets as I have them to give everyone an opportunity to testify. So with all that having been said, I do appreciate you bearing with me, but I think it'll be easier if everybody kind of understands what's expected of each other tonight. So we will start with Senator Goodwin, who has with her Luke and Tellis to answer any questions that the committee may have on her bill. Could just get the number for you. Senate Bill 2492. Senator Goodwin and Mr. Entelis. Good evening, Madam Whip, and welcome.
Thank you, Madam Chair. Members of the committee, let me begin by thanking not only yourself, Madam Chair, but each member of this Judiciary Committee for co-sponsoring this very important piece of legislation that has come to be known as the red flag legislation. So thank you for your co-sponsorship. I'm grateful. And it speaks to the importance that the Rhode Island Senate thinks of this particular piece of legislation. Let me just introduce to the right of me Luke Entelis, who is a lawyer from every town, for whom I was happy to sponsor this bill. Madam Chair, I'm just going to take about 2 minutes of the committee's time. I'm just going to give a brief outline of what this red flag legislation does. And if you have any questions of myself or Luke for technical aspects of the legislation, we'll be happy to endeavor to explain. The purpose of this legislation is to create a new type of restraining order for a person who poses a danger to themselves or others with guns. Law enforcement and family members can seek a court order to temporarily prohibit the dangerous person from possessing firearms and requires the surrender of any firearm in their possession. This bill adds a new chapter to our state law, creating an extreme risk protection order. This bill establishes who can seek them and when the guidelines of the court will consider before they issue. The bill spells out how that will happen. If a family member or law enforcement officer believes a person possesses a significant danger to themselves or others and has access to firearms, they may file a petition in the Superior Court here in the state of Rhode Island requesting an extreme risk protection order. If a temporary order is granted, the court must schedule a hearing within 7 days of the issuance of a temporary extreme risk protection order in order to determine if a 1-year extreme risk protection order should in fact be issued. There is a process for the return of firearms after the order has been lifted, as well as a hearing for persons who wish to contest the order. A nationwide study of mass shootings from 2009 to 2016 revealed that in at least 42% of those incidents, there is documentation that the attacker exhibited dangerous warning signs before the shooting occurred. My hope is this bill will also help with suicide prevention. Nearly 2/3 of gun deaths in the United States are a result of suicide. It is reported that an estimated 72 or more suicides have been avoided in Connecticut following a 2000 study of their red flag law that has already been enacted. When those who recognize red flags are empowered or have a system to act upon, they can helpfully prevent future heartbreaks. I understand that there are some valid concerns, Madam Chair and members of the committee, with this legislation, but it is my hope that these issues can be considered and addressed quickly so that we can ensure passage of this very important legislation. Thank you, Madam Chair and members of the committee, for your time.
Thank you, Madam Whip. And I do know that since this legislation has been put in, there has been significant discussion and significant work put in to it as well. I was just briefed as late as about 5 minutes ago about some of the things that have been brought up. So it's certainly something that will be continued to work on. Mr.
Thank you.
Antelis?
I want you just to understand this will be a work in progress for the committee's, edification and for members of the public that are here to testify.
Thank you, Madam Whip.
Thank you, Madam Chair, members of the committee. Thank you so much for allowing me to testify this afternoon in support of this important legislation that would create an extreme risk protection order in Rhode Island. My name is Luke Antelis, and I'm a counsel with Everytown for Gun Safety. Everytown is the largest gun violence prevention organization in the country, representing 4.5 million supporters and more than 250,000 donors, including moms, mayors, survivors, and everyday Americans who are fighting for public safety measures that respect the Second Amendment and help save lives. The purpose of this legislation is to create a new type of civil restraining order so that when a person is in crisis and poses a danger to self or others with guns, law enforcement and family members are empowered to seek a court order temporarily blocking the person from having guns. When those who recognize red flags are empowered to act, they can prevent warning signs from turning into tragedy. We do know that in many cases, people who go on to commit violence display warning signs first. As the sponsor mentioned, a nationwide study of mass shootings from 2009 to 2016 revealed that almost half the time, the attacker exhibited dangerous warning signs before the incident. According to media reports, the mother of the 19-year-old who shot and killed 17 students and injured 15 others in Parkland, Florida, last month, contacted law enforcement multiple times about his behavior. Unfortunately, Florida does not have an extreme risk protection order law. I also want to highlight the impact that this policy can have on the problem of gun suicide. America is absolutely in the midst of a firearm suicide epidemic. Guns, as you just heard, guns are used in over half of suicide deaths, and access to a firearm triples the risk of death by suicide. But preventing a suicidal person's access to firearms can save his or her life. The estimate that you just heard about put the total at 72 lives saved by Connecticut's extreme risk protection order law. That's 72 lives, people's brothers, mothers, cousins, and their kids. This bill would create a process to empower Rhode Island families and law enforcement to temporarily block gun possession by people who pose a threat to themselves or others, while providing robust due process protections to people experiencing a crisis. The bills would create a new chapter within Title VIII. The chapter would establish and define red flag orders, how they can be sought, and by whom. The chapter would establish the factors that the courts must consider and specifically set out the standards of proof required for a court to issue an order. They will also set the duration of the orders and the processes for renewal and for termination. The bills will also establish the process by which guns are to be turned in when an order issues and how guns are returned when the order expires. As with all court orders that can impact individual liberties, the process created in these bills was designed to ensure both public safety and the due process rights of all parties involved. The bills establish clear and appropriately high standards for the showings that must be made before a court issues an extreme risk protection order. The bills make clear the factors that the court must consider and the burden that the petitioner must meet before an order can be issued. Petitions for these orders must be sworn under oath and must contain specific factual allegations in support of the claims that the respondent poses a significant danger to themselves or others. And there are safeguards in the bill to protect against abuse and to punish those who seek orders maliciously. Any petitioner, be it a family member or law enforcement officer who knowingly files a false petition or who files a petition with the intent to harass or to annoy someone else, is subject to criminal prosecution. The bill also ensures that all parties have an opportunity to be heard on the merits of a petition. Only in the most serious cases Where an emergency order is necessary to prevent imminent harm, can an order be issued before a full hearing. These emergency orders can only last up to 7 days, as you just heard, at which point a final hearing must be held. No final order can be issued before the respondent has an opportunity to be heard and to present evidence of why the order is not necessary. And the bill gives a person subject to an order an opportunity to petition the court to terminate it. I strongly urge you to pass this important legislation, and I would be happy to answer any questions.
Thank you. Any questions or comments for this witness? Thank you.
Madam
Oh,
Chair,
I'm sorry,
real
Mr.
quickly, I'm
Senator
sorry.
Raptakis.
You mentioned something about Florida did not pass earlier. You said something about the state of Florida, because they did yesterday pass a whole package. I'm not sure if you looked at what was passed under mental health illness. There's a certain components, but you mentioned something earlier.
Yes, sir. Thank you. I mentioned that Florida does not have a law like this one that this bill would create in Rhode Island. It does not have an extreme risk protection order.
Well, have you seen what they passed as of yesterday? The state Senate in Florida passed a whole package that could be familiar to what we're having here today, the discussion on this bill.
I'm generally aware of that, yes.
Okay, thank you.
Thank you. We have several other sponsors here who would like to present their pieces of legislation before we move on to witnesses. Senator Seveny and Senator Sheehan. Senator Sheehan.
Thank you, Madam Chair. Thank you, members. Thank you, Madam Chair. Thank you, members of the judiciary. I'm here on Senate Bill 2271, along with my colleague, Senator Seveny. We also have the same legislation. I'll start by saying my other job is a historian, and I know that if we don't learn from our own history, we're doomed to repeat it. Why did I introduce this legislation, which is a prohibition on bump stocks and other similar devices? Well, obviously, it was October 1 when a gunman opened fire on a crowd of concertgoers at the Route 91 Harvest Music Festival in Las Vegas, slaughtering and taking the lives of 58 innocent people and injuring another 851 concertgoers. The gentleman in question was a 64-year-old, the assailant, Stephen Paddock. He fired some 1,100 rounds from his suite on the 32nd floor of the nearby Mandalay Bay Hotel. After about an hour, he fired his last shot into the crowd. We found him. He was dead of his own self-inflicted gunshot wound. This was the deadliest mass shooting committed by an individual in the United States. It reignited, of course, our debate about gun laws in the United States, as incidents since then have. And this particular incident focused and highlighted the bump fire stocks, which Paddock used to allow his semi-automatic rifle to fire at a rate similar to that of a fully automatic weapon, which is unlawful in Rhode Island. That is why I introduced this legislation, Madam Chair and members of the judiciary. This act, if enacted, would make possession or use of a semi-automatic weapon rapid-fire device, including bump stocks, binary triggers, or trigger cranks, punishable up to 10 years imprisonment and a $10,000 fine. This act would take effect upon passage. There is no legislation that's perfect. There's going to be no panacea to curbing violence of this sort. But if we can only reduce the number of people, if that gentleman, Mr. Paddock, did not have a bump stock, might there have been fewer people killed, fewer people injured? I'd like to think so, and I think that it would be the case. And I'd like to bring that form of protection to Rhode Island as preventative medicine, Madam Chair. Thank you.
Thank you, Senator Sheehan. Any questions or comments for Senator Sheehan? Thank you. Senator Seveny?
Thanks, Madam Chair. Members of the committee, thanks for having me. Part of the issue with this is that there's a gap in the law. This dates all the way back to the National Firearms Act of 1934, where, for whatever reason, the ATF has found that the trigger housing, the trigger mechanism, is not covered under the law that prohibits the possession of a fully automatic weapon, of a machine gun. And this has lingered on through the various laws. And so as it stands today, as we all know, things like bump stocks, binary trigger, which allows you to fire a weapon when you depress the trigger and then again when you release the trigger, trigger cranks, which are actually a cranking device that allows you to shoot a semi-automatic weapon like full automatic. This fills that gap, and it bans all of these devices that, in one way or another, manipulate a trigger that allows rapid fire, approaching the rate of fire of an automatic weapon. If you look on YouTube, it's loaded with examples of all of these devices, and the rate of fire goes up almost to 700 rounds a minute, which is pretty close to what a military M16 or M4 shoots at. These are, in fact, machine guns once these devices are either attached or incorporated into what otherwise is a semi-automatic weapon. This bill, of course, does not apply to the police, and it's not construed to prohibit use of a replacement trigger. I mean, it's quite normal for anyone who owns a gun to manipulate the trigger pressure in the course of being able to shoot a semi-automatic weapon. And this bill does not prohibit that. It's simply the devices that increase the rate of fire substantially. So with that, I'm happy to take any questions you might have.
Thank you. Are there any questions or Senator Archambault?
Quick question, Senators. Have either of you thought about putting a provision in that gives a period of time for compliance? There may be a host of people out there, law-abiding, that have these devices, and if this law were to pass, would instantly become felons.
Yes.
Maybe they need a period of time to get in compliance. Have you thought
In
of
fact,
that?
I was speaking just to the House sponsor of this companion of my legislation, and we had that discussion today. I think that's an excellent suggestion as a would-be amendment to have something of a grace period to either turn them in or give an opportunity to dispose of them. Thank you.
Thank you.
Yeah.
Any other questions? Senator Sevigny, I apologize.
I mean, I would be willing to entertain some relatively short window in time for this to happen. I mean, these devices are easily added to a weapon and easily removed. It takes minutes to either attach it or disassemble it.
But I think, at least for my part, I would like to give, obviously, the law-abiding public who bought them lawfully prior to, say, an enactment of legislation, an opportunity to become aware of it through education and other efforts. Thank you.
Thank you. Any other questions or comments for either of these senators? Thank you.
Thank you.
We have several. I don't see any other senators that are not on the committee that have bills before us today. There are two witnesses I'd like to call next. Captain Borick from the Rhode Island State Police and Addie Goldstein from the Governor's Office. Captain, I thought you were here for crowd control. I apologize. I didn't realize you were here to testify, but we'll start with you. Good afternoon and welcome. Just make sure the button is up, Captain. There you go.
Okay, sorry about that. Good evening. Thank you for having the Rhode Island State Police here today. The Rhode Island State Police is in fully support of the bills from the Senate here today pertaining to Bill 2271, 2289, 2292, 2319, 2492, and 2493. Senate Bill 2289 would restrict possession of concealed weapons on school grounds to peace officers and persons approved by education institutions. That's something that's dear to me, with the state police being the head of the school safety committee. So that would be a great thing because we don't need to introduce weapons in our schools. High-capacity magazines and rapid-fire devices. Obviously, we know the dangers of those today, what's going on in our society, what happened in Vegas. We want to minimize individuals from having these types of additions to weapons for rapid fire. Also, Bills 2319, which would ban high-capacity ammunition magazines. Senate Bill 2493, which take the long overdue step of banning military-style assault weapons in Rhode Island, joining Connecticut, Massachusetts, New York, and a number of other states. And then Bill 2492, the red flag law is something that we're fully supportive. Just a couple of recommendations to that would be a more streamlined process for law enforcement on taking those weapons once it's ordered by the courts. Another thing would to incorporate ammunition when seizing those weapons. And then finally, if we're going to take a concealed permit away from an individual, we should also look at taking their hunting permit away from them as well. In that.
Thank you, Captain. Are there any questions or comments for Captain Borick? Captain, I would just ask you to continue to be in contact with the sponsor as we continue to work on this, just so that we keep your recommendations in mind.
Thank you, and the state police is willing to work whatever we can do to ensure.
Thank you. Ms. Goldstein, good afternoon and welcome.
Thank you very much, Madam Chairman, members of the committee. It's on? Yes, great.
As long as the button's up, you're all set.
Madam, 3 weeks ago tomorrow, the shooting in Parkland tore at all of us. Since Governor Raimondo has taken office, she has ordered the state flag to half-mast at least 9 times because of mass shootings. 9 times. We can no longer wait for Washington to act on guns after Parkland. The governor helped establish the States for Gun Safety Coalition to study gun violence, and she signed the nation's first executive order to establish a red flag policy. But we need legislation to establish a permanent law with mechanisms to remove firearms from dangerous individuals. The governor appreciates the leadership that the legislature has shown to take very swift action to improve public safety and keep Rhode Islanders safe from gun violence. While it is true that Rhode Island has some of the nation's strongest gun laws, and that is also partly why we have some of the lowest rates of gun violence in the country, but it is also true that our nation has some of the weakest gun laws in the world, and that it falls on us, on states, to keep military-grade weapons out of the hands of civilians. And that is why the governor is in very strong support of the bills that have been proposed to ban military-style assault weapons, high-capacity magazines, bump stocks, and other mechanisms that transform already very dangerous weapons into even more lethal weapons. Last year, the governor and the legislature came together to take guns out of the hands of abusers. It was a common sense move. And this year, we are all again poised to take another step forward, thanks to strong advocacy from all our children. Madam Chairman, members of the committee, we thank you very much for your efforts in proposing this red flag law. We believe it is a strong law. As the chairman has already noted, there are certain steps we can take to further improve this law, and the governor's office is committed to working with all members of the General Assembly to help improve this legislation and make it into law as quickly as we can. Thank you.
Thank you. Any questions or comments for this witness? Thank you. The next couple of witnesses I will call are Julie Wyman and Frank Sicoscio.
Thank you, Madam Chair.
You're welcome. Good afternoon and welcome.
Thank you, respected committee. My name is Julia Wyman. I'm one of the founding members of the Rhode Island Coalition Against Gun Violence, and I serve as their volunteer legislative director. The Rhode Island Coalition Against Gun Violence has just signed up our 100th member, together which we now represent 120,000 Rhode Islanders. I'd like to thank you for this opportunity to present this argument, but I realize we have many other people, and so I will be as brief as possible. We support the Safe Schools Act, which is Senate Bill 2289 by Senator Metz. It provides that only peace officers, as defined under 12-7-21, and persons approved by school authorities for the purpose of educational instruction may have firearms on school properties. Currently, anyone in Rhode Island with a concealed carry permit can carry his or her firearm into Rhode Island K-12 schools without the knowledge of police or school administrators or anyone. There is completely unfettered discretion about carrying a loaded firearm in our schools. 46 states generally prohibit the carrying of concealed carry guns in K through 12 schools, even by concealed carry permit holders. Rhode Island is an outlier in its approach to guns in schools compared to the rest of the country. There are only 4 states that generally allow guns in schools, and each of those arguably have good reasons to do so, in that they have schools that are in very remote locations, away from police and other circumstances. Our law really exists as an outlier, I believe, because it was implemented in 1990, which was 9 years before the Columbine shooting, well before we started considering the issue of arming school teachers. And so the question becomes, how do we deal with this? And what we came up with is a proposal that would allow persons who are defined as peace officers alone to carry loaded firearms on school grounds to protect children, but not generally concealed carry permit holders. We understand that many of the people here who may have concealed carry permits are well-intended and quite proficient at shooting, but when put under circumstances of live fire and challenges whether to shoot or not to shoot, these are very highly skilled decisions that police and people who are trained as peace officers are uniquely qualified to possess. We don't believe that teachers should be armed. We don't believe that anybody should be armed unless they're trained peace officers or law enforcement. Together with the Rhode Island Police Chiefs Association, we are supported in this position by the Rhode Island Education Leadership, which includes the Rhode Island Association of Schools and Principals, the Rhode Island Association of School Committees, and the Rhode Island Federation of Teachers and Health Professionals. Polls show that 82% of registered Rhode Island voters supported restricting concealed carry in elementary schools. We think it's time, especially in light of the heightened awareness about guns in schools, that we have an honest conversation about this issue, and we ask that you pass this bill through the committee. Do you have any questions?
Any questions or comments for this witness? Thank you. Mr. Sicoscio, good evening and welcome.
I have other bills to present on. Did you want me to go through
Oh,
all of
I'm
them?
sorry. I thought
Yeah,
nope. I
not gonna
want
go
you to
fast
do
then.
all of them now because I imagine Mr. Sicoscio is going to take a minute as well.
Oh, okay, so
go ahead.
through them. Okay, thank you, Madam Chair.
Only a minute.
Only a minute. Might take a little bit longer. Sorry about that. Next, we are in support of, let me just get my glasses, sorry. The 2 bump stock bills that were just testified about, we wholly support them, and just would comment that we hope that they would not serve as a substitute for also passing a high-capacity magazine bill and an assault weapons ban bill. We fully support the Senate Bill 2319, which would render illegal the purchase and possession of high-capacity magazines, which is defined as more than 10 rounds. This law would reduce the number of rounds that could be shot before a shooter has to reload, and that's the critical issue here. We know that generally there are 30-round magazines, as much as 100-round magazines, and the point of this bill is really to force a shooter to reload their firearm each time they run out of rounds. Connecticut, Rhode Island, Connecticut, Massachusetts, New York, New Jersey have all passed this law. There are a total of 9 states that have passed it, and it has been upheld in, by my count, 5 different state Supreme Courts. I think, you know, a lot of talk we've had a lot of discussion about this bill in the past, but more recently, I noticed that according to Professor Siegel of Boston University, some more recent data that I think is helpful, he stated that whether a state has a high-capacity magazine ban is the single best predictor of a mass shooting rate in that state. To be clear, we're not saying that there's a correlation between that state's laws and banning high-capacity magazines and a lower rate, but rather that there is a relationship between the two. Since 2012, we have seen 63% lower rate of mass shootings in those states that have banned high-capacity magazines. Another point I want to make is that a separate study that was done in the Journal of Urban Health in October of 2017 found that high-capacity magazines have been used in over 40% of murders of police in recent years. This report was co-authored by the investigator of the congressionally mandated assessment of the 1994 federal assault weapons ban. And so it's a highly commissioned study, and the fact that police are directly implicated by allowing these high-capacity magazines to continue to exist in our state is alone an incentive for banning them. So we ask that this committee pass that bill as well. Moving on to the more difficult issue of assault weapons, we support this bill because it seeks to ban future purchase and possession of assault weapons, but it also has a grandfather clause allowing people who currently own them to keep them and make it subject to a background check upon subsequent transfer. Military-style weapons like AR-15s are made for one purpose and one purpose only, and that is to kill as many people as possible. And I've heard time and again that these are sporting rifles and that they're used to protect one's home. But we have seen from San Bernardino, where 14 people were killed, 49 people in Orlando, 58 in Las Vegas, 26 in Sutherland, Texas, and now 17 in Parkland, Florida, that that's not the case. In fact, they're being used for the commission of malice and hatred. And it's time that we as a society, and especially as Rhode Islanders, consider where our values are. When we make decisions, we make them based on risk-benefit analyses in the law and in life. And so we have to weigh the benefit of being able to use a sporting rifle and for the gun lobby to make a profit against the risk that people in society are walking around fearful to be in their schools, fearful to be in public places, the risk to our police communities. It's time that we got on board with our neighboring states and ban assault weapons. Do you have any questions or comments about the bill as proposed?
Somebody up here is bashful, don't worry. Somebody will jump in and interrupt you if they do. So just continue.
We are also in support of the Extreme Risk Protection Order bill, the AKA Red Flag bill, sponsored by Senator Goodwin. We wholeheartedly support it. We realize that there are different versions of it, and we reserve judgment on the final draft. The one thing that we would just say is that whatever version that is ultimately decided upon, that it be mindful and considerate of the fact that many people in the mental health community are often stigmatized when we talk about guns and violence, and it's far and away more likely that persons with mental health problems are indeed the victims of violence, not the perpetrators of violence. Carrying long guns in public places, that's Senate Bill 2274. That's an Attorney General bill sponsored by Senator Miller. It makes unlawful any person to carry a rifle or shotgun in any vehicle or conveyance on or about his person, whether visible or concealed. Currently, people can walk around carrying long guns, rifles and shotguns, and in fact, assault weapons in our public spaces, unbeknownst to me. This bill simply seeks to make long guns subject to the very same requirements as pistols. We wholly support that bill and hope you do as well. The straw purchaser bill, which is Senate Bill 2615, again, that's an Attorney General bill sponsored by Senator Miller. It provides that no person shall knowingly purchase or otherwise obtain a firearm on behalf of or transfer to a person whose transfer knows or reasonably should know is prohibited from possession or possessing or receiving the firearm. The Rhode Island Coalition supports this bill because straw purchasers are the gateway to crime guns, including, for example, the massive number of straw purchasers in Indiana that supply guns in Chicago. We wholly support that bill and hope you do as well. Lastly, in terms of bills that we support Senate Bill 2455, sponsored by Senator Coyne. That bill makes the AG the sole issuing authority for concealed carry permit holders. We have no objections to the language other than to say that there is language that says that the local police chiefs would be consulted and shall cooperate with the AG's office. We would prefer to see the language to say that the AG shall consult the local police chiefs and that the local police chiefs shall cooperate, because we think it's critically important that local police who best know their community and their residents should be consulted before issuing a concealed carry permit. As far as bills that we oppose Senate Bill 2148, which allows persons with concealed carry permits issued by other states to carry their firearms in Rhode Island if they recognize Rhode Island CCP holders. We wholly oppose that bill. And I'm going to dive a little bit deeper into this and why. When I did a search of what states have reciprocity with Rhode Island, and that's, I should say, one-way reciprocity, because in fact we don't have reciprocity with them, but they allow our CCP holders to come to their states. I pulled up the list of those states. There are 23 of them. The problem is that, with the exception of Michigan, which is one of the 23, all the others have very lax requirements compared to Rhode Island. 10 of the states don't require safety and proficiency training. Rhode Island does. Forgive me, 16 are shall issue states. In Rhode Island, we have discretionary-based issuance of concealed carry permits so that the Attorney General may, but must not necessarily allow someone to have a concealed carry permit. 16 of the states that are part of those 23 states have a shall issue standard. So basically, we are lessening our standards by allowing these concealed carry permit holders to come to our state and carry loaded firearm everywhere in our state, because again, that's the scope of where you may carry in our state, everywhere, including our K through 12 school settings. So we object to that. There's no way for police to verify whether an out-of-state person has a valid concealed carry permit. At the insistence of the gun lobby, there is no database for such information, much less an interstate verification system. States widely differ on their permits. Some have photos, others don't. It's wrought with problems. Another point I'd like to make is that Rhode Island is the host of over 24 million tourists. We are very fortunate, considering that we're a population of just a little over 1 million. And indeed, a goodly portion of our budget, if not maybe one of the first or second portions of our budget, stems from our tourism. These are festivals, bars, beaches, restaurants. We pride ourselves on our growing reputation as a family-friendly tourism destination, which is reflected in all of these ways. We do not want to invite untrained, poorly vetted, unverified people to flood our public spaces with loaded firearms. We think the law is very bad for Rhode Island and our economy. That is the only bill we oppose, amazingly. We have no position on Senate Bill 2134, sponsored by Senator Archambault. That's the Attorney General report bill that it basically requires that there be a report maintained by the Attorney General's office, unless, of course, it is deemed that those reports are already being undertaken in Rhode Island, for instance, by the gun court, Judge Crass, because we would not want to see our resources expended on duplicative efforts. To the extent that it does get modified, however, we would like to see the categories expanded to include domestic violence abusers, as well as persons who've applied for concealed carry permits, because we think that would be very helpful information. We have no position on Senate Bill 2276, sponsored by Senator Metz, which is in regard to possession of firearms by minors. And we have no position on Senate Bill number 2606. Again, that's an Attorney General's bill that has to do with obliteration of toy guns that are made to look realistic. We have no position on that either. That is the entirety of the bills that I have on the docket for tonight, and thank you for hearing me out.
Thank you very much for your testimony. Are there any questions or comments for this witness? Thank you. Frank, good evening and welcome.
Good evening, everyone. Thank you very much for allowing me to speak. My name is Frank Sicoscio, just by way of introduction. Most people on the panel already know me. I am the president of Rhode Island Second Amendment Coalition. I am an attorney licensed in Rhode Island, Massachusetts, and all the federal courts. I am the city solicitor for the town of Johnston, and president of the Rhode Island Second Amendment Coalition. Let me go over some of the bills that we have before the Senate today. First bill I want to talk about is Senate Bill S2134. That's the Gun Reporting Act for the Attorney General's Office. The reason why we're in support of this bill is the Attorney General's Office needs to be accountable for what they do with regard to dispositions in cases. A couple of years ago, we actually challenged the Attorney General's Office and said, how many of these cases do you plea away or you drop if they're gun-related? And the Providence Journal actually fact-checked us. It came back as approximately 90% of the gun charges in Rhode Island either plead down or dropped. That's not, and we actually had the Providence Journal fact-check that. The legislature needs to know that if you're passing gun laws, that they're being enforced, and they're being enforced correctly. We can't keep putting gun laws on the books if the Attorney General is not enforcing them. So you people need to know that. The Attorney General has consistently, over the last couple of years, said, we don't want to do that, or they have an opposition to this. Why would it be an opposition? It's once a year they come in and they explain to you what they're doing with the disposition of these gun cases. So let me give you a for instance so you'll understand why we are in such a support of this bill. Give you a case that we're following out of Johnston. 3 o'clock in the morning, a couple of people go into the Denny's in Johnston. These people actually happen to be gang members, and at 3 o'clock in the morning, they start a fight in Denny's. One of them has a Smith & Wesson 9mm, takes the gun out, starts waving it around to the patrons. A fight ensues. They leave Denny's. The police are called, and they're in the parking lot. The police actually catch the people in the car with a loaded Smith & Wesson 9mm. To make matters worse, that firearm had obliterated serial numbers. The person had gang affiliation. The person was from Delaware. The judge let the person out. The Attorney General, this happened February of 2017. This person had no ties to the state of Rhode Island. The allegations were they're waving a 9mm around in Denny's, and the person's out. The Attorney General's office did not bring an information till October of 2017, 8 months later. And where's that person? Gone. They put it down for a PAC date in December of 2017. Defendant never showed up. They put it down in the gun court for January. The defendant still didn't show up. That person is now, right now, there's a warrant outstanding held without bail. Does anybody know about this? Does the Attorney General office report to you, the legislature, say what they're doing to enforce these gun laws? That's why we need this reporting bill. This is something the legislature needs to know about. So this is, let's make matters let's make matters a little bit worse for this case. When the person, this gang member, was arrested, he was already wanted as a fugitive from justice out of state, and they still let him out. This is why we need reporting on this of what's going on with the Attorney General. The legislature needs to know if these gun laws are being enforced. We really do. Senate Bill 2274. This is the one where it adds in long guns and shotguns, and it creates a prohibition against people traveling with them. The reason we have a little bit of hesitation with this is it seems to create more of a defense. So somebody could be driving to the range, could be driving someplace else, get pulled over, and they happen to have firearms in their car. Even if they're unloaded, locked in a case, an officer can arrest that individual and say, you know what, go to court. You prove that you were going to the range. You prove that you were going to the gun store. It creates a defense. During the meantime, somebody's life is ruined because of that. They have to hire an attorney, go to court, and they're facing charges. But now, it's great. Now we put a defense in there. You now have to prove in court that you were doing that. It's kind of a little bit of a dangerous bill. It hasn't been added there, and for good reason. Let's talk about Senate Bill 2289. This is the gun-free zone bill. This bill could not be a worse bill. We've been up here for the last 5 years arguing against it. I stated this when I was on Channel 10 the other day in Newsmakers. I'll say it again. Every parent with a child in a K through 12 school in Rhode Island should be absolutely furious at what the Moms Demand Action are doing and the Everytown people are doing. They're trying to institute the exact same failed gun-free zone that was in Newtown, Connecticut, that was in San Bernardino, California, that was in the Pulse nightclub in Florida, and now sadly again in Florida just recently. When are they going to wake up that gun-free zones don't work? All they do is attract people that are going there to create harm. If you look at the FBI reports, actual real reports, go back 50 years, every single mass shooting except for 2 or 3 has happened in a gun-free zone. We want to put that in our K through 12 schools? A gun-free zone is not a solution. We need real security in our schools. We've been saying this for the last 5 years. No one is listening. After Sandy Hook,
Senator Archambault.
Actually, just to interrupt you quickly, because it's not on the calendar, I actually, Senator Lombardi and I have talked to Rep. Amori on the other side, and he has a bill to require a police officer at every school. And I'm going to put that bill in, and Senator Lombardi's putting the bill in for the funding mechanism to be able to pay for it. It's really well thought out. I don't think that the League of Cities and Towns are going to feel warm and fuzzy about it because there's an expenditure within the budget. You know, the lion's share of town revenue is eaten up by school committees, as it should be, for the higher education of children. But the bill would require there to be a police officer at every school, just for the reasons you just said. And I don't think either of you would be opposed to that. So, but you can continue.
Okay. Okay. Now, after Sandy Hook in 2012, the NRA actually put together something called School Shield. This is a program they put together where they have grants, where they will actually come out and work with law enforcement to take a look at the schools and give you an evaluation on risk. Not once did anybody ask about that. They will actually come out and work with law enforcement and say, where are the risks in our schools? And what can we do to improve them? It's a free service. There's grants that happen. But no one is listening to us to try to improve the security on that. These are things we should be doing to enhance security in our schools, not putting out a sign out front saying, oh, this is a gun-free zone. To make matters worse, they're putting it on their website that this particular town or that particular town has now passed a resolution to say, we don't want any guns in our school. Why don't you just put a big flag out there and say, we're not going to have any security in our schools? It's absolutely terrible. I wish people would listen and say, let's work on real solutions in our schools. Now, with regard to...
Senator Metz.
Yeah, if I can, Mrs. Kosho, in a way I agree with you, but by the same token, you can't have people running around in the schools with guns, because if you have someone, and the law is specific that it's peace officers, and as Senator Archibald just said, and the co-sponsor in the House, if it's peace officers that have been trained that are on duty in the school, that's one thing. But just someone walking in and having something on them, it's a whole lot different. Just like down there in Florida, that gentleman was trained and didn't even go in the building. So now you want someone to walk in the building that may have a gun, and it's a whole lot different. It's a whole lot different when someone's shooting at you. So I agree with you in one respect, but the best thing is not to have them around unless it's a trained police officer that's in the building. So that's the only thing that I disagree with you on.
Well, I respectfully disagree with you. If you look at the exemption for this, for people who have CCWs on school grounds, this was put in place by our Attorney General in 1990. The reason it was put in place in there was in the event we needed to have private security or additional security in school, we don't have to have police officers. We could have trained officers that have possibly been retired and now are not functioning under the police department's authority. They could use their CCWs issued because they're retired and actually be in there as a police force. Without their exemption, they're felons if they walk onto the school grounds. In addition to that, if you look at it, since 1990, approximately 28 years, we've had 0 instances in Rhode Island of a CCW holder going on school and doing anything, hurting anyone. So unfortunately, 28 years of experience and history are against you on that one. Now, when I was on Newsmakers, Linda Finn sat there and said, you don't have any examples of CCW people helping out. You can go on, and I brought paperwork today, and I will submit copies. In the last month, 22 separate incidents of CCW holders stopping crimes. One of them mass shooting, one of them helping police stop and apprehend an MS-13 gang member. CCW holders are actually law-abiding citizens. You can't look away from the fact that they have been licensed by our Attorney General's office, by our police departments to carry anywhere in this state. They are the safest people out there. To sit there and say, if we have them in their school, they're going to be running around and carrying a gun, they are. And for 28 years, there hasn't been a problem. Why are we changing it now? I could tell you right now, if we put people in here, in this room, that were in the Pulse nightclub, or in San Bernardino, or in Sandy Hook, and said, if you could go back in time and put one CCW holder on that ground to take out that shooter before he killed all those people, would you do it? I bet every one of them would say yes. But you want to take that option away.
Yeah, if I can.
Senator Metz.
I respectfully disagree. I respectfully disagree. And if they come in and they got a pistol, and the person that's doing all the shooting got an AR-15, they got enough common sense that they wouldn't do that. I've been in the service myself, so there's a whole lot difference. You have a handgun and someone else got an automatic weapon. So that's all I'm going to say on that. I respectfully disagree.
Well,
If we could just have the audience, you'll all get your opportunity to speak. So if we could
Okay.
just have one witness at a time.
all right. So
Mr. Secoshio.
I'll move on. I think I've beat
Thank
that one
you.
up enough. Let's go to Senate Bill 2319. This is the magazine limitation. In 1994, we had the assault weapons ban. This was a federal ban, and it limited the magazine capacity to 10 rounds, and it also banned whole classes of firearms. I know this because the firearm that I carry, a SIG 228, was actually purchased during the time that the ban was in place. It was actually manufactured pre-ban, but I couldn't get the factory 13-round magazine that came with it. I had to get a 10-round magazine with it. Okay? We have 10 years worth of data from that. That federal ban went away due to its sunset clause. There were two separate studies on that to find out if it had any measurable effect on crime or violence. Both independent studies came back. These are independent studies from the government. You can check, and unlike other people that come up here, I'll actually give you where the statistics come from. The Task Force on Community Preventive Services and the National Institute of Justice did surveys on this. One of the reports is over 100 pages, 170-something pages. And they came back and said, no measurable reduction in crime or violence. It doesn't work. We have 10 years worth of data to say it doesn't work. So we're going to do it again? We have proof that this does not work. Now, if you want to take a look at and say, well, some people are fighting for this to say, well, if we have a magazine limitation, it would allow individuals, police officers, to go in there and stop this. We have yet to see examples coming forward where the police have said, yes, the person had to reload, so during that 1 or 2 seconds, we were able to go in there and take them out. It's coulda, woulda, shoulda defense. Doesn't normally work, okay? Now, police officers carry firearms. There is not a police officer in Rhode Island that's going to carry a 10-round magazine. They carry as many rounds as they can in their magazines. Why? Because in the event that their life or the life of somebody else is in danger, you don't want to limit the amount of ammunition you have on you. So why do you do that to a civilian whose life might be in danger? Somebody who's carrying a firearm for home defense. Does it make any difference? Is their life any less valuable than the police officers? Massachusetts and Connecticut have done this. They've limited the magazine capacity. Has anyone come forward and said, since they put that in place, look at the fantastic reduction in crime? In fact, it hasn't. It doesn't have an effect because it only affects the law-abiding citizen. Let me explain to you the real-world application. Magazine I carry right now, well, not on me because I'm in the State House, but it's 13 rounds. This bill passes, I can't carry that 13-round magazine anymore. You know what I'm going to do? I'm going to carry 2 10s. So the real-world application is you're going to make me carry more ammunition. It doesn't work. If you know somebody who has a firearm, they can change the magazine in a split second. This has no real-world effect. All it does is infringe upon law-abiding citizens. If there were some statistics, if there were some studies, if there was something to say this works, the firearms community would probably be behind it. It doesn't work. We have other states that have done it. It doesn't work. Going to the assault weapons ban, which is Senate Bill 2493. Again, going back to what I stated before, from 1994 to 2004, we had the assault weapons ban in place. Didn't work, didn't reduce crime. Why? Because law-abiding citizens are the only people that are going to comply with this. It doesn't work. It hasn't worked in the past. Creating a registry in Rhode Island, it's illegal. We've had it for years where they said we shouldn't have a registry. This also would put a $25 fee on every person that had a firearm, $25 fee on every person that wanted to register each individual firearm. You're putting a burden on people for legally owning the firearms. They might not have used these firearms for years. You want them to register these? Think of what you just did to the value of that. You can't sell it to another private citizen. You can only sell it to a police officer, only sell it out of state. The value of that firearm just went down. And I got to say this, I put this on the internet the other day, and I had a ton of responses from it. For years, people have looked at us in the firearms community and said, you know, you guys are conspiracy theorists. No one's coming for your firearms. They don't want to ban them. They don't want to take them away. How about now? Think we're all crazy now? This ban would effectively limit my ability to buy any more or restrict me to selling them. In effect, what you're doing is stopping law-abiding citizens from exercising their constitutionally protected right to buy additional firearms. And are we the people that are causing the problems? No. Does nothing for security at all. Okay? Let me give you another little fact that I don't think anybody has brought up yet. In 2012, Connecticut passed similar legislation. You guys all remember the news stories that went out? 80 to 90% of the law-abiding firearm owners in Connecticut refused to comply with the law. Even at the cost of becoming felons, they will not register their firearms. They were interviewing the police officers and state police, and they were saying, we're not enforcing the law. You can take a look at it, Google it, the reports are still out there. Even the police were saying, we're not going to go take the firearms. Even if they don't register and they're felons, we don't care. They're not enforcing the law. You saw civil disobedience on a massive scale. Why? Because the law-abiding citizens are not your problem. Go after the criminals. Go after increasing security on schools, increasing other things. These don't work. In addition to that, if you create this type of assault weapons ban, what you do is you now have a clear definition. Anything other than a musket or a bolt-action rifle, other than a fully automatic, would be lumped into here. Almost every other firearm could be considered a semi-automatic based on simply cosmetic features. Forward assist, thumbhole stock, collapsible stock. It doesn't do anything. Once you create that big gap, that big class, very easy for them later on to go, not even grandfathered, you got to turn them in now. It would effectively take out probably 75% of the firearms that most people own, legally. Okay? So, I usually talk too much, so there's some other bills I'm going to let other people do it because you're probably sick of hearing and listening to me speak. But I'll take questions now, so.
Thank
Okay.
you. Any questions or comments for Mr. Sicoccio? Senator Nesselbush.
Just quickly, Frank, I'm interested in the registry. If we don't have a registry to know how many guns someone has, if we were to have a red flag law, policy, however we get there, so if somebody horrifically says, I'm going to go kill school children, and I'm not really feeling all that, with it these days. And we do seek through some, yet to be lawful means to take those guns away. How would we know without a registry if they have 1 or 10? Like, how would we be able to actually effectively take the guns away from somebody who's dangerous?
Okay. Great question. So as a solicitor for the town, Johnston, I deal with the police department pretty regularly, and I usually get teased pretty often because every time I buy a new firearm, the officers go, "Hey, heard you bought a new Remington." They know. Every time that I buy a firearm, it has to go, the transfer has to be approved, not only with the regular federal paperwork, it has to go through the town that you own, that you live in. So the police department in the town know every single firearm I own already. It has to be approved by the police department. I have clients that have come in the office that said they had cases expunged 10 years ago, and the police department still deny a transfer. So the police department already knows. To have a registry just creates a list, which they already have anyway. But the police departments know every single firearm I own that I bought, it goes through the police department. They know. So the registry, it really wouldn't be something that I would be willing to say that's okay, it's fine.
Thank you. Senator Jabour.
Frank, thanks for coming before the committee. You are very knowledgeable and always have a good insight. It's a very good balanced. I think we all know that the question of gun ownership has been out there forever in our country. And I read an article. It actually wasn't until, and I didn't know this until I read the article, it wasn't until 2008 that the Supreme Court actually established that there is a individual right to gun ownership in America.
Yes.
And Judge Scalia wrote the majority opinion, although our court was very divided on that issue. Tell me what your opinion is with regard to Judge Scalia had some very interesting remarks in that majority decision. I think it was called the Heller case. And I just want to read something to you and then tell me what you think. Judge Scalia said, "Nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools, government buildings, or laws imposing conditions and qualifications on the commercial sale of arms." Now, I'm looking more at, obviously, the reaction here is with security of children in schools. Maybe the bigger issue now is those, rather than a felon showing up at a school or a public place, it appears to be someone who has mental illness issues. Tell me what in this legislation does not address what Judge Scalia is talking about, because the Supreme Court seems to be saying that it is giving the legislature some room to create some prohibition for specific situations. And it seems that the majority of the bills here are reactionary to what we've seen going on in America.
Okay. So what you're talking about is you want to say, would it be, if I'm trying to think your question a little more narrowly, do you believe it'd be constitutional if there was a restriction on the ability to carry for a CCW holder on school grounds? Is that what you're talking about?
I would think more the question would probably be, is there anything in this bill that would violate someone's rights, considering either what their mental stage is or what their criminal record is? You, I think, have a perspective from a good standpoint that, there are a lot of lawful gun owners and they follow the law. And so your perspective seems to be here that somehow we're going to be taking those rights away from lawful gun owners and tipping the balance with regard to security for children in the schools. What in these bills that I'm saying would be so drastic that would truly infringe on that Heller decision I don't think it's going to take away any rights, would it? Because I remember a couple of the sponsors saying one of the most important things that the public has to understand, and I think it was a member in the House, is that the priority of this body is not to be harmful to lawful and responsible gun owners. I think that should be known here.
Okay. So let me see if I can answer the question. It's kind of a multiple question on that. With regard to security in our schools and stuff, with regard to restricting a CCW holder's ability to go on school grounds. Currently, right now, the law, if you get a CCW holder, there is a section of the statute that says you can lawfully carry anywhere within the state. There's a specific exemption that says you can carry on school grounds. When you look at any infringement on the Second Amendment, the Supreme Court has already looked at that and said that anytime you infringe on it, that infringement has to be weighed against, you have to look at a legitimate state interest, weighed against the constitutional right. Those balancing texts have to be taken a look at under the strictest scrutiny, which meaning there can be no other reasonable restriction at all to accomplish the same state end for the security of the individuals. By sitting there and saying that an individual who's passed all the tests, his license to carry anywhere in the state, and just saying an absolute complete ban on not being able to go on school grounds, I think that fails strict scrutiny on that because there's no reasonable alternative to that. When I go to the courthouse, I have to lock up. If I go to another place, they may have the, well, you can't do it here even though they got lock boxes, but there are lock boxes available for people that carry concealed. So that would be a reasonable alternative to doing that. But simply banning it and saying you can't do it, I think it would fail a constitutional challenge just in that area because it fails strict scrutiny.
So looking at the language by Judge Scalia, what you're saying is that the bills need some sort of working up and having some language that would pass the scrutiny is what you're saying?
Yes. Anytime you infringe on a constitutional right, it has to be weighed against the a standard of strict scrutiny. There can't be any other reasonable alternative or it fails.
Okay, thank you.
Thank you. Senator Raptakis.
Frank, welcome to the Judiciary Committee. I got a quick question, a couple of questions for you. Recently, the state of Florida, the Senate, just passed a package of bills. I thought you were going to get to S2271, which is the bump stock prohibition. And I know that Florida has, the Senate, Florida passed a bill 456, which is probably similar. Have you looked at what was just passed yesterday in the Florida State Senate versus this exact bill of 2271? The reason why I'm getting there is we're using Florida as a barometer and of what happened. And I don't want to go overboard here in Rhode Island what took place in Florida. I mean, we're going to try to pass some type of legislation that makes a lot of sense, not something that goes overboard. But if you compared what was passed in Florida the other day on bump stock prohibition versus what is here today, because you didn't get to that bill. Okay. I'm not sure if you looked at either or.
I did not look at Florida, but I can tell you what my opinion on the bump stocks is, and then I can tell you what the firearms community is. My opinion of the bump stocks is, in 1986, the Department of Alcohol, Tobacco, and Firearms said, we are the ones that are going to be regulating any fully automatic firearms, including the specific components which make a firearm semi-automatic, make it fully automatic. So they're not banned, but they are highly regulated. Only a few people with a special license can own those. What happens is, years ago, ATF came out with a letter and said the bump stock itself, the device, does not pigeonhole, does not fit into any one of their prohibited items. So therefore, it kind of snuck around what the ATF considers to be their area to prohibit these fully automatic firearms and the firearm components. It didn't go any further to say it's legal. It just says currently right now these bump stocks are not prohibited by us. And they said check with your local authority. You take a look at 1147, which we have right now, which is a prohibition against anybody owning a fully automatic firearm. What happens is, legally, right now, under our law, you can own the bump stock. You can have it. It's like you can own this. I can have this piece of paper right here. I can own it. It's not prohibited. I can't do anything with it. Once I attach it to a firearm, I violate 1147, that section which deals with machine guns. So just simply attaching it to a firearm makes it illegal, makes it a felony. So my own personal opinion, I think it kind of skirts around the federal prohibition passed in 1986 on that. But we have a gap in our law, which we probably want to fix. The firearms community is kind of neutral on it because there are some people that want the bump stocks, some people that don't want the bump stocks, don't care about them. So we're kind of right in the middle of that. So we're kind of taking a neutral position because everybody's hasn't come to a consensus on that.
On this bill here in front of us that we heard today, you're taking a neutral position.
Neutral position because even the Attorney General came out and their position on the bump stocks is they're illegal. Same thing that I said, they are illegal, they're a felony. The problem with the bump stock bill right now as written, it has a definition of a high-speed device. That language in there is so unconstitutionally vague that it would fail. I don't know how anybody would prosecute it. I don't know how anybody would defend against it. What happens when you have a section of law that you put in here or you make a definition or you put it into a bill, if an individual, reasonable person cannot reasonably say what is prohibited or what I can and cannot do, it fails a constitutional challenge because it's vague. How would you know what components, what modifications violate the act or don't violate the act? I'll give you an example. If you're having a problem, if you have a 22 caliber rifle or a pistol, what happens? 22 sometimes are very finicky. You have to polish the ramp on the inside so they don't get caught and it'll feed and stops for the jams. All that does is make the firearm more consistent. It doesn't jam. You may have a police officer, attorney general, and says, you might modify the firearm so another round slides into the chamber a split second faster. Did you modify it and make it a high-speed device now? You could ban it. So a person doesn't know what that does. I personally, because of the firearm I carry, my .228, the spring got weak in the magazine. That's because the magazine was manufactured in 1991. So I bought a replacement spring for that. The springs they have now, the replacement springs, are 2 pounds heavier. I can't get the factory spring. So am I going to be violating the law in a high-speed device because it pushes the round up faster into the chamber? How do I know? The section that you put in there with high-speed devices is absolutely unconstitutionally vague. How is somebody to know what could be a modification to make it a high-speed device or simply making it more reliable or more accurate? You can't have that. You can't have a section of law that does that.
And
that was the problem I had.
One more last question real quickly. On the issue, I'm not sure if we have a bill that's been introduced regarding the purchasing of someone under 21 of purchasing a firearm other than a handgun. I think federally you cannot purchase a handgun if you're under 21. And again, the package that in Florida that just passed prohibits a 21-year-old from purchasing a firearm other than a handgun. We know that you're going to be 21 years old to purchase alcohol. You're going to be 25 years old to rent a car. What's your opinion if we passed a bill that bars someone under 21 for purchasing other than a handgun?
My opinion would be this. Do you have any statistics at all to say that would actually make everyone safer? Has raising the limitation, the age, done anything in any other states to make people safer? Because if we're going to pass bills just to pass bills, why are we going from 18 to 21? If we can't say that what we're doing is helping, why are we doing it?
Do we have states that have completely prohibited anyone under 21 years old from purchasing any type of weapon? Do we have that? Any states have done that?
Not that I'm aware of.
So there's
I don't
no
have
states.
the statistics in front of me. I'm
So
sorry.
we can't use those statistics then, because there's no states
I would
other
have
than
to
under the
see.
federal law.
I would have to see if it made people safer. I think a lot of people were behind it, but I'd want to see the data first, see if it actually works.
Thank
instead of
you,
just
Frank.
passing laws.
Thank you. Any other questions or comments for Mr. Secoshio? Thank you. The next group of witnesses we have are Joey Lembeck, Colonel Mendonca from Central Falls, and Chief Mello of Jamestown. Joey, we'll start with you. Good evening and welcome.
Thank you, Chairwoman, and thank you for the committee for this important conversation and this long night. I was in the other room, so I just wanted to address a couple things I did hear. Senator Aptakis, the Attorney General, has filed his intention to file legislation increasing long-arm purchasing up to 21. We did a final draft of the bill today. It should be in the hands of Senate staff by the end of the week, so we are filing that legislation. I know you have a long night tonight, so the Attorney General is opposing 2148. We are supporting 2442. We are supporting 2319, the high capacity ban. We are supporting 2493, the assault weapon ban. We have filed lengthy testimony on all of those bills, so I'm just going to talk about the bills that we have significant concern with or that we have sponsored. On Senator Goodwin's bill, Whip Goodwin's bill, the red flag bill, we are in full support of that bill. We are working on amendments that are mainly technical in nature to tighten that bill up, and we are happy to work with Whip Goodwin and this committee to do that. There's a couple of points that I wanted to bring up, though, from our sister state in Connecticut. They started doing risk warrants in 1999. From 1999 to 2013, they issued 762 of those orders. Firearms were found in 99% of those 762 orders, and of that 99%, at least an average of 7 guns were found per individual that the risk warrant was given out for. So it's clear that red flag orders save lives. So we're thankful to Whip Goodwin for putting that bill in. Regarding Senator Sheehan and Senator Sevigny's bump stock bill, when the bump stock incident happened in Las Vegas in the fall, our office was forced to look at our current laws to see if bump stocks were illegal. We made the determination that if someone attempted to make a gun automatic under our law using a bump stock, that would be illegal. We also found if someone was in possession of the tool while in possession of the gun, we could show intent to make it automatic. That would also be illegal. But the mere possession of a bump stock is not currently illegal on Rhode Island law. We think that it needs to be made very clear in the general laws that these tools are illegal to possess and to use, and these bills do that. And I did attach to your testimony a letter about over a majority of the attorneys general nationwide sent to Congress.
Joey, I hate to interrupt you, but I know you were listening to a great majority of the testimony.
Yes.
The only question that came as a result of that bump stock bill had to do with giving some sort of notice or a time frame if that bill were to be enacted for those
Yes.
people who did own one so they didn't automatically become a felon. Is that something that the general could support?
Absolutely. We've been talking about that a lot. When you have normal assault weapons bans, like the 18 to 21 ban, that bill will be looking forward so you could track it through a serial number. Bump stocks don't have serial numbers, so we would absolutely support a grandfather clause. We've spoken about it.
Senator Archambault.
Joey, in the collection of, and I know that the red flag bill is not your bill. In the collection of data that you've looked at between Connecticut and other states that have enacted similar legislation, have you looked at the period of time for the restraining order hearing and the due process commensurate therewith? I'm looking at the number 7, and I'm wondering where that number came from. And I'm thinking of last year with the other bill that was passed for the gun violence, and you know there's a problem with the restraining order that's trying to be worked out now with the Supreme Court because mechanically it just doesn't work with fundamental due process. As good as that bill is in many ways, that there's an issue there. So I'm thinking of that when I see the number 7 here. And you're always good with statistics. Can you say anything to that?
We know that other states, I think that Washington has 14 days. California might have 21 days, but it's in that span, that 14 to 21 span. I have all the bills in the Senate Judiciary Office for the 5 states that I can certainly break down to you which states do what with numbers for the time for the hearing.
And I'm curious if I could follow up, Madam Chair, and I'm curious as to what may be the lowest number of days that one could have a hearing to protect fundamental due process, because the thinking of some of the prevailing minds who deal with this every day in family court and district court is that there needs to be a shorter period of time, and then that time would include a full hearing so that these property rights can be dealt with right up front with the allegations so that due process is fully intact. I know you're familiar.
Yep,
with what
I
I'm
will
saying.
get you those numbers.
Thank you.
Moving on to Senate 2134, which is Senator Archambault's bill. We did put written testimony in. The Providence County Gun Court, where a vast majority of our gun crimes and gun prosecutions take place, they issue a report monthly. So that is the report that provides all those numbers. We think that creating a report of this nature would be duplicative in nature, and people always actually have the ability to file an APRA request or look on the court documents online that are all there to see our dispositions. But I did want to comment to something Mr. Sakosha said about 90% being cleaned down, and I haven't been able to find that on the Providence Journal, but I certainly will. I mean, holding the Attorney General accountable, which I hope that all voters in the state would. But I think that people need to understand that when a gun case is charged, there's probably about 7 different counts that are charged. And any normal plea deal, counts of that will be dismissed. So just because there are counts of the indictment or information dismissed doesn't mean the case is dismissed. And regarding the gang member in Johnston in February, when our office does an investigation regarding a criminal complaint filed by local law enforcement, having that go through our screening process does take a while. And it's unfortunate that the person was let out on bail, especially if he was a fugitive from justice, but there are only several crimes in our state that are held without bail, and those are set by the Rhode Island Constitution. Gun crimes aren't part of them. Bail is presumed in gun cases, so following the bail guidelines, the person probably appropriately did get bail. If he was a fugitive of justice, that needs to be really looked at. But I did want to point out that gun cases are not hold without bail cases. If they are, the Constitution needs to be amended.
Senator Archambault.
Thank you, Joey, and I appreciate that you had mentioned that there may be some duplicity with the bill, but you know that as the top law enforcement officer in the state of Rhode Island, the Attorney General is the one we turn to for a feeling of soundness that the statistics coming out of that office are accurate and the data is something we can rely on. And right now, we don't have a reporting mechanism for the General Assembly, so I'm not so sure that the burden on the agency would be so great that we couldn't have the Attorney General's office take what's presently out there, streamline it with this bill, and then annually have someone as articulate as you and as well-informed as you come before the General Assembly on behalf of the Attorney General and enlighten us as to what those statistics are so that we can adapt in real time, because the incidence of crime is something that concerns everybody in the room, and we want to make sure we're doing the right thing with any adjustments to things. So and it's your office that's looked upon for the veracity and soundness of those.
And we do issue an annual report every year to the General Assembly about what our office does as a whole, including our crime statistics. So I'll bring a copy of that. We just think it would be duplicitous to do it more. In regards to Senate Bill 2274, that is a bill sponsored on behalf of the Attorney General, and that's the carrying a long gun down the road. Right now, an 18-year-old could go into a gun store, buy an AK-47, and walk down Smith Street to no avail. That's completely illegal in this state. We find that troubling. We call it the Omer exception in the wire, where someone can just walk down the streets of Pawtucket, the streets of Warwick with a loaded long gun, rifle, or shotgun. This bill attempts to codify what we do for concealed carry permits, but do it for long guns too, but not get the permit. And I wanted to point out something Frank said, that he was concerned about this bill because it would create a new defense for people, that they would have to hire a lawyer to defend themselves in this case. The same exemptions for long guns are the same exemptions that have been in the law for short guns for the last decades. So this doesn't create a new standard. Everyone that carries a firearm understands the provisions of having it in their home, their vehicle, or in their place of business. So the same exemption would apply to the long guns. We think it is very dangerous that people can be walking around our state with a loaded shotgun. And that's currently the state of the law. It occurred in Central Falls a month ago, and Colonel Mendonça can talk to you about that in a little bit. On 2276 right now, for a minor to be convicted of possession of a firearm, they must also use it. We know that in our urban core, gang members are using the youth to hold on to their weapons because the penalties are less, if at any. So we think this is a very dangerous loophole in our law that we're waiting to charge a minor in illegal possession of a firearm just because they didn't discharge it. We think that's a very bad signal to send. In regards to Senator Coyne's bill, Senate 2455, bringing full jurisdiction of concealed carry permits to our office, we are in full support of that bill. And there's 3 things I want to point out regarding that bill. Having 2 concealed carry permit standards is very inconsistent and creates confusion, let alone when you do the 2 different laws and then there's 37 other agencies interpreting those laws. Of 2 distinctions, though, AG concealed carry permit holders are subject to the 7-day waiting period. Municipal concealed carry permit holders are not. One of the biggest things that makes 7-day waiting periods so important is the NICS check. If the federal government runs a NICS check and the conviction is incomplete, they call back to the jurisdiction to get the court records. If there is no waiting period, that gun is being sold without that confirmation being complete. So it's really ridiculous to have the AG permit holders subject to the 7-day waiting period, but not the municipal carry holders. That's inconsistent. The other thing that's the difference is that the AG permits are entered into NCIC, which is the Federal Criminal History Database, meaning if someone gets pulled over in Rhode Island and has a concealed carry permit, law enforcement can see if the person has a concealed carry permit, which is a public safety standard for both law enforcement and the concealed carry permit holder, so everyone knows there's a gun involved. For the municipals, they're not entered in. So there's no knowledge by law enforcement if you have a concealed carry permit and they are pulled over that the person has a gun on them. And we think that's a safety issue. And then finally, we do the vast majority of permits in the state. The last time we counted, it was above 80%, but those numbers might be different. That was several years ago. But we are doing a vast majority of the concealed carry permits. And this year, 2017, we had 2,335 active permits from the AG's office. We had 645 new applications. 83 of those were new applications, and 565 were renewals. The next bill is Senate Bill 2456, and this isn't really a gun bill, but it has to do with concealed carry permits. Right now, our office and law enforcement have no way to do a fingerprint check to the FBI for a national background check. We don't have the statutory authority. For the FBI to accept our prints, we have to have a statute that says they can. So that leaves us looking through III on every single state's record to complete a national background check, which is entirely burdensome when all that would have to be done in a normal cycle is just send a print and have it come back. That's what we do with every national background check in the state, but we can't do it with this concealed carry permit application. It's really a no issue other than the price of the background check, which is $35 for 4 years. But it's really an administrative burden for our office and law enforcement. For Senate Bill 2606, that is a bill sponsored by us, by Majority Whip Goodwin. That's about the orange tips in the laws. We've seen incidents over the last 5 to 6 years where people are removing the orange chips that are federally required on toy firearms or imitation firearms and removing them to make it show it's real in a robbery or a B&E. Or people are inserting the orange chips into a real gun to make it appear fake. We have alteration of firearms in our general laws that that criminalizes people that alter firearms. This would include orange chips into that alteration. If you put an orange chip into a real firearm, that would be a felony under this bill. And if you remove the orange chip from a toy gun to be used in that crime, it would be a misdemeanor. And we have seen cases of that in Rhode Island. And then finally, 2615, which is Chairman Miller's bill about straw purchases. A straw purchase is when I go buy a gun for Colonel Mendonça, who's not lawfully allowed to have a gun, and I buy it and give to him. That's a straw purchase. States across the country have that bill, have that law. It's been held up by the United States Supreme Court in 2014. Rhode Island doesn't have that law. So if anyone is making straw purchases in Rhode Island to evade federal and state statutes on who can carry and purchase firearms, there would be no way to charge them criminally under state law. That is a very big concern that should be addressed by this body. I will rely on my written testimony. I'm open for any questions.
Thank you. Any questions or comments for Ms. Lembeck? Thank you. Colonel, good evening and welcome.
Good evening. Thank you for the opportunity. Rhode Island Police Chief Association is in support of Senate Bill 2271, which makes possession of the use of a semi-automatic weapon, rapid-fire devices, including bump stocks, binary triggers, and trigger cranks, unlawful. Also, 2274 it makes it unlawful for any person to carry a rifle or shotgun in any vehicle conveyance and about their person, whether visible or concealed, subject to certain exceptions. I will give testimony on that. We are in support of 2276, criminalize the possession of a firearm by a minor. Senate Bill 2292. This makes possession of use of semi-weapon, rapid-fire device, including bump stocks. That's duplicate bills 2292 and 2271. 2245, regarding the opportunity for determine suitable person. Chief Mello will give testimony on that. Senate Bill 2456, regarding providing the applicant for gun permits to submit a national records check, including fingerprints to the FBI. And we are supportive of 2292, regarding persons subject to extreme risk protection order for being in imminent danger of causing personal injuries shall surrender all firearms while subject to the order. Also, we'll be giving testimony on that bill as well. We are supportive of 2293, restricts possession and sale of new assault weapons, limits magazine capacity to 10 rounds. We are supportive of 2206, defines limitation of firearms provided is lawful for any person to change, alter, remove, or operate or obliterate any coloration of markings in any way and makes the imitation of firearm looks to be operable firearm. We are supportive of 2615 regarding providing that no person shall knowingly purchase or otherwise obtain a firearm on behalf of, transfer that person, the transfer that known reasonably should know is prohibited from possessing or receiving a firearm. To begin with our testimony, again, I want to speak on 2274, personal involvement with that. Just recently, on January 23rd of this year, late afternoon, around 3:45, officers responded to reports of multiple shots fired in a Pine Street and Ranch Street area. Actually, during our investigation, we actually found the weapon. It was one of the weapons that were involved in the shooting. But during the chaos that ensued, it was a subject that was walking down the street carrying a duffel bag with the barrel of the weapon actually protruding from it. Of course, the officers were alarmed. We stopped him, searched, come to find out it was a loaded shotgun. He also had drugs in his possession, but because of the current law, we released him with the Rhode Island Traffic Tribunal summons for the possession of marijuana under an ounce, and we were not allowed to charge him with walking down the street with a loaded shotgun, and again, of the miss of the reports of shots fired. So the situation was chaotic, and due to that circumstances, obviously somebody could have been easily hurt, if not for the change in the law where that person could be charged. Now we have no charges for that individual. I would like to defer to Chief Mello in regards to 2255.
Thank you. Thank you.
Thank you, Colonel. Chief, good evening.
Good evening. Thank you for the opportunity to offer testimony this evening. I'd like to offer testimony in regards to Senate Bill 2492, commonly referred to as the red flag law. As you are probably all aware, a number of weeks ago, the Police Chiefs Association hosted a meeting in which about 35 police chiefs from throughout the state were present and began the discussion about the red flag law. Many of us shared examples of how we have been challenged with similar fact patterns as you saw in Parkland, Florida, and just really unnerving of the limitations of the law as it exists today. I'm going to offer you just an example from Jamestown, not a community you might think of or comes first to mind when you think of gun violence, but nonetheless, we have our own challenges in Jamestown. I'll give you 3 examples. It was a number of years ago that I was made aware of an individual, 19-year-old resident, posting on social media, very clear intent, according to his social media posting, to commit horrific crimes against children in a school in Jamestown. We knew that that individual, once we identified who it was, had attempted suicide on a number of occasions. We knew that that individual had access to a school based upon his mom working at that school and had accessed that school on a weekly basis, although he had no other business to be there. We knew after searching his computer that that individual had access or was attempting to access the purchase of multiple firearms. Along those lines, I know there was testimony about gun registry and a particular bill. I would tell you that was a particular challenge for us because we were trying to determine whether that individual actually purchased a firearm. There's absolutely no way for us to tell if an individual purchased a firearm legally in Rhode Island or not. There is no database that exists for that. Based upon the mental condition of that individual, we were able to convince him to seek mental health treatment. I would suggest to you, though, that when he is released from a mental health facility, there would be absolutely nothing that would preclude him to go purchase a firearm that day. If that's not alarming to you, I don't know what could be.
Senator Archambault.
Thank you, Chief. First and foremost, I didn't serve under you, but as you know, pleasure to have you here. But you just touched on the word. You're the first one to say it this evening about mental health. And I'm going to say it, and then I'm going to listen to the rest of the testimony. But I think our emphasis, thank you. I think I'm going to say it, and then I'm going to leave it alone. I think our emphasis as a body, as a legislature, and our emphasis on all sides should be on increasing the amount of resources that we put into mental health screens commensurate with all background checks. And I think that people on both sides, the NRA and the Mothers Against Gun Violence, all stand for the common thread, which is safety. We want a safe society that we all live in and flourish in. So we want to find the people that have mental illness that want to hurt people. And we had this study some years back, and some statistics came out of it, but nothing was ever really fully implemented. I had a CCW bill on earlier tonight, and I pulled it for a lot of the reasons that Joey touched on, which is that there isn't comity among the Attorney General and the local police organizations. And I favor CCW permits, but the way that the bill is written, it's not up to speed with the changes that we have to make commensurate with mental health screens and long enough background checks so that law-abiding people who should have firearms can have them, and those people that are crazy are ferreted out. So I know that you've personally been involved, and I want to thank the Police Chiefs Association for the amount of time that they put into the mental health emphasis. Rep. Chikarchi and I sponsored a bill last year that passed that enabled police officers to teach and get taught, that is, at the police academy in mental health training, and it's really the vessel for red flag and other changes in the law to actually occur. But it's going to take an active effort by people on all sides to focus on mental health screens and long enough background checks that dovetail in with the mental health screens. And I'm not a book of answers. I'm not sitting here like a book of answers. It's going to take a collective effort to do this in a way that preserves the Second Amendment rights and at the same time finds those people that are crazy, that are going to get the guns. And, you know, I've polled people on all sides, and everybody agrees. I haven't had one person dissent on this. So I just want to throw that out there. We should be talking more about mental health screens and long enough background checks to find the people that are crazy, that are going to hurt people. But I didn't mean to interrupt you, but I wanted to say it up front, and it was the perfect time. So go ahead, Chief.
It does, I absolutely agree, Senator. There does seem to be a commonality there in the concerns, I think, by everyone revolving around mental health concerns, whether it's the thoroughness or lack of ability to conduct a thorough background check when issuing a concealed weapon permit or processing the application for a firearm. There's a lot of gaps that need to be addressed in that area. So I'll offer you just two other examples. as the red flag law may apply. I had a mom, she has a 19-year-old son, mental health issues. She approached me last week, and she asked me if her son would have the ability to buy a firearm, if there's anything prohibiting him from doing so. Been in and out of mental health facilities for about 2 years. And her impression was that the mental health professionals had stopped that ability for that individual to happen. And I shared with her the reality is he can walk in today and buy a firearm. That's a concern. That's a mom who's terrified, who has a family history of suicide in her family by firearms. You can imagine her fear when I told her that. It's very common that police officers encounter suicidal people. Very common that they involve firearms. Oftentimes, we are faced with seizing firearms, getting that person to a mental health facility. But the reality is, without this law, as soon as they are released, they can have those firearms back, and they can go purchase additional firearms. There's an example of why this law, I think, is an important tool, exactly what the senator was alluding to try to help us address, in most cases, what would be a mental health concern. In regards to bill number 2455, which puts the entire burden of concealed weapon permit applications with the Attorney General's office. The Police Chiefs Association remains in support of this for a number of reasons that have been cited, that there's a central repository for them, there's the ability to allow for that 7-day waiting period. There's a consistency in the background check in what mental health treatment or mental health concerns may be involved with applicants. We continue to support that particular bill. So I thank you for the opportunity, and we are prepared to answer any questions that you may have. Thank you.
Thank you. Are there any questions or comments for these witnesses? Thank you very much. Senator Miller has arrived, and I apologize for not getting to you sooner, Senator, but if you want to come and present your bill, now's the time.
Okay, I'm going to try to be very brief because I know you have a lot of people waiting to testify, and I have different access to discussing these issues with you on a later date that these people who are going to testify don't. So I'll try to be very quick on this. And my bill, of course, I feel it's very important. I've had it over time, at least 3 or 4 times. So I think an assault weapons ban bill is very important. But I want to touch on what Senator Archambault discussed, which is screening for mental health. And I'll go into that a little bit more, but I want him to be aware the way I discuss this bill and other bills is that I think, screening for mental health is very important. But the Las Vegas shooting and the Parkland shooting, both of those, we might not have caught those people with further screening for mental health. And as far as an assault weapons ban is concerned, those guns were acquired legally, and we can do better than that in Rhode Island. My concern is also, and I know you've had testimony and you'll have further testimony probably from law enforcement, that they want to be protected out in the street, that they're outgunned in the street. And the people who have those guns probably have never had encountered a situation in which they would be mental health screened, never mind access to health care or mental health care. They're just not screened for mental health and probably wouldn't be caught if they were. So I think we need more protection than what just one bill does. And that's a real crux of my testimony, is that it's not about one bill. We've reached a point where I don't think we'd solve this problem with one bill. We had a job training package. We had a package where we reformed the commerce, the EDC, what used to be EDC. It didn't take one bill to do that. It took 10 bills to do that. The opioid overdose crisis, we didn't solve that with one bill, and we're not going to solve it with one bill. We had 8 bills last year on this. The justice reform package was at least 10 bills. In order to make families and students and law enforcement feel safer in Rhode Island, it has to be more than one bill. And I wanted to get to Senator Rep. Taka's point about we're going to use Florida as a barometer. I don't think Florida is the right barometer for Rhode Island. Florida doesn't have a governor supporting this legislation, doesn't have an attorney general supporting this legislation. It doesn't have the polling numbers that Rhode Island has that we saw today. It doesn't have 34 legislators on the red flag bill, 34 senators out of 36. It doesn't have 19 out of 36 on the assault weapons ban bill. It doesn't have a vast majority of support by not only legislators, the attorney generals, law enforcement. These bills have a tremendous amount of support. So what I hope you hear from, and I know you're going to hear from people other than myself who have a really important voice, is, I hope you hear from the student when you consider magazines and assault weapons. Hope you hear from the students that want 3 seconds, the shortest time in which you can reload a magazine that they could get out of a room. I hope you hear from law enforcement that also wants that 3 seconds. I hope you hear from the surgeons, the doctors, that go from a wound that's treatable from a piercing injury from a .22, rather than the untreatable wound from an explosive injury from an assault weapon that we're trying to ban. I hope you hear from that surgeon. And I hope you hear from the lawyers that will explain to you that not only at the Supreme Court level, but when we talked about assault weapon bans, whether we talk about magazine restrictions, whether we talk about bump stocks, that the appeals courts, the local courts, the appeals courts, and the Supreme Courts have ruled that those restrictions in Massachusetts, Connecticut, New York, New Jersey, Maryland, and DC, and several other states have all met the scrutiny that the courts have gotten those legislation. And I can guarantee you that if these bills aren't in the same condition as the bills that passed that court scrutiny in those states, we're ready to make them able to meet the court scrutiny in those states. So I'll reiterate one thing I said the other day when we signed these bills last week, the assault weapons bill especially, that I really hope that we do what it'll take to make students and teachers feel safer in their classrooms. And one bill will not do that. I think all of these bills will bring us closer to doing that. Remember the time, because it no longer exists, when parents were really excited to see the excitement on a student's face because of the learning experience they had that day in school. And what do they come home with in the last few weeks? Fear and anxiety. I think we have to do something based on that, if nothing else. Thank you, and I'll take any questions.
Thank you, Senator. Senator Jabbour.
Thank you. I want to thank Senator Miller for the sponsorship. But, Senator, you, back in February of last year, we had the Health and Service, Human Service Committee have mental health hearings, and I know Senator Archibald was addressing some of those issues. What in those findings, you did mention justice reinvestment. I noticed there was something in there, too, with regard to psychiatric services, the lack of number of psychiatrists here in Rhode Island, and issues with insurance premium, getting people mental health. What is in that report that can help us with the gun legislation?
Well, I think, I talked about when I was addressing Senator Archibald's concern about getting more mental health scrutiny as part of the permitting process, and if we do red flag and how it pertains to that also. My concern in being in the health chair and looking at these issues and having a mental health package that hopefully improve mental health access to mental health services, that we have a real shortage of everything but inpatient, and that's why it's really expensive in Rhode Island. We don't have we have a lot of gaps in inpatient care. And what it does to gun bills and the kind of scrutiny that we want around mental health, First of all, it leaves out the vast majority of Rhode Islanders and Americans who never seek mental health treatment, and therefore they aren't included in part of the screening. And so we have gaps. People don't access mental health care. So it's really tough and subjective to make it more part of the process than it should be, and and to improve. It's part of why we are where we are, and it's why it's more complicated than one bill or one effort.
Because that report, the finding and recommendations, I think, is a very good starting point when you try to put a glove on the legislation. The problem is, as you state, everybody doesn't come in contact, and part of the Justice Reinvestment Commission, everybody's not in contact with the criminal system who has these issues. So how do we find them until something bad happens? So thank you, Senator.
Thank you. Any other questions or comments for Senator Miller? Thank you. Mayor Alorza, good evening and welcome.
Good evening, Chairwoman, and thank you very much for taking on this very important matter and for your thoughtful consideration. And thank you to all of the members of the panel. As Mayor of the City of Providence, we've made taking on gun violence an absolute priority. And we've done this through a multi-step, multifaceted initiative that addresses the problem from a number of different perspectives. And, you know, we start with one common sense principle, and that's that the more guns that are out there in our community, the more likely it is that we're going to see gun violence. And no one is suggesting that the measures being considered before this committee today are the only measures that should be taken. There are other common sense steps that we should take. But these common sense steps that are being considered today are certainly some that have proven effective and that will save lives. The unfortunate truth that we are all confronting is that the atrocities that we've seen on TV, sooner or later, whether we like it or not, are eventually going to happen in Rhode Island as well. And it's only a matter of time before someone walks into a school in our state and starts randomly killing children. And through what we're considering today, we have the ability, if not to completely prevent something like that from happening, but to limit the number of children who are affected. Many other states, including our neighbors, have banned high-capacity magazines and assault weapons. And now it's often said that this is an assault on the Second Amendment. It is not an assault on the Second Amendment. Just as we don't allow anti-aircraft artillery, we don't allow grenade launchers. Those are weapons of war that don't belong in our communities. These military-style assault weapons are also weapons of war. They are designed to kill as many people as possible, as efficiently as possible, without having to change rounds if we allow high-capacity magazines. They do not belong in our community. And we have the opportunity to join 40 other states and Washington, D.C. to protect our kids from senseless gun violence by banning guns in our schools as well. Banning guns from school grounds cannot be all we do if we want to prevent gun violence in our communities. Up until 2004, as I'm sure you very well know, there was a federal law in place banning the sale of high-capacity magazines. Since the federal assault weapons ban expired in 2014, there has been an increase of 183% of more incidents and 239% increase in deaths related to mass shootings. There's a clear connection here. And I challenge anyone to formulate a good argument of why we would allow military-style assault weapons in the hands of people who would walk into a school and indiscriminately kill children. It just doesn't make sense. We do not know where the next mass shooting is going to take place. It could be a church, a school, a grocery store parking lot. Who knows? We have seen too many deaths, too many mass shootings, too much to wait any longer. We can save lives by banning assault weapons and high-capacity magazines and by keeping kids out of our schools. It's time that we act and we take these thoughtful and considered steps with these life-saving bills. Thank you.
Thank you, Mayor. Senator Archambault.
Mayor, it's always good to see you.
Great to see you.
The bill that Rep. Amori's working on is not drafted yet. I'm going to throw it at you. I don't want to tie you down on it, but I want you to keep an open mind with respect to that bill when it comes before you, because there's going to be some moaning from the League of Cities and Towns, and respectfully, I mean that respectfully, because municipal budgets are finite, and you don't have much elasticity, right? You either have to cut or you have to get the revenue somewhere, and there's a cost associated with having a police officer at every school. When we talk about safety in our public schools, that's certainly a bill, if you had a police officer at every public school, that would be difficult for anyone on any side to criticize, other than the mayors who, one in particular may be cringing at me saying this, at the budget and the cost associated with it. So as the largest municipality in the city, in the state, I'd ask you to keep an open mind in light of everything you just said on that bill.
I'll keep an open mind, particularly if the state pays for it.
Senator Jabbour.
Thank you. I just want to welcome Mayor Elorza, our mayor, to the State House. Mayor, thanks for coming out and voicing your opinion on behalf of the residents of the city of Providence. One thing we do have in Providence, you have great leadership in our public safety department. Our Chief Clements and Commissioner Parry are on it in the city of Providence daily. I know that you're constantly in contact with them. Our community policing program and our ability to be out in the school zones and have community policing and people there, I think has helped us to stop what the terrible thing that may eventually happen here in the state. But I'm glad that Providence is on it, and I appreciate your leadership on that issue, Mayor.
Thank you, Senator, and I appreciate your support.
Thank you.
Thank you. Any other questions or comments for Mayor Elorza? Thank you.
Okay, thank you.
The next group of witnesses we have are Mike O'Neill, Mike DeLauro, and Elizabeth Burke-Bryant. Mr. DeLauro, we'll start with you. Good evening and welcome.
Thank you, Madam Chair and committee members. I'm here tonight to testify in opposition to 2271, 2492, and 2615. I'll start with 2492, the Extreme Risk Protection Order Bill. I was out of the room earlier, but when we learned about this bill, we started doing a little bit of research, and we learned that 5 states have laws like this. The one nearest to us is the state of Connecticut. I'm also told that there are a number of states as we speak, including Minnesota and Florida, I believe, that are considering similar legislation as this. So the concerns that we have with the bill are, when we looked at it, we thought first that this was akin to a restraining order type of piece of legislation, something along those lines, and it really isn't. the amount of intrusions into one's personal life and affairs that are empowered by this bill, if it were enacted into law, are quite extraordinary. So what we decided to do was to look at the legislation not as a restraining order type bill, but more as a search warrant type bill, because really the type of intrusion that happens when law enforcement executes a legally obtained search warrant is pretty substantial. So what drew our attention in the provisions beginning on page 2 about the information of the documents that have to be submitted to the court prior to the order being granted are very much free form. We thought that one of the things that would help in fixing that would be if a provision was added regarding probable cause, and we didn't see one. Now, later on, once the hearing happens, there is a provision regarding clear and convincing evidence. So we think that in order to, if you're going to trigger something as intrusive as this, it ought to be at least based upon probable cause, which is contained in the Fourth Amendment to the Constitution and I think Article 1, Section 6 of the Rhode Island Constitution. We're concerned also about the criminal penalties that would result as a violation of this order. If this really is about, we know that it is about public safety and also about getting mentally ill folks, as has been the case across the United States. To get them into treatment, we think it best not to criminalize violations of the order. I will tell you that this is consistent with what we've been talking about up here this year. This is the first time on this side, but we've been talking about our caseload study, which I'm going to make available to the committee later in the week, which talks about the caseloads of my office regarding criminal cases. Some of the other provisions that we're concerned with regard having proper procedures in place to protect confidential health care information and information provided by third parties regarding health care. And we're also concerned about the requirement that the court could order a mental health evaluation based in an ex parte proceeding. And lastly, perhaps most important, there's nothing in the that we saw that would provide for the appointment of counsel for indigent defendants, and that causes us great concern because you'd want to see something like this to be used effectively and not be used for more sordid or untoward purposes. And yet, if you leave it as broadly worded as it is, that may result. Our position on 2271 and 2615, we think that with 2271 rather, which is the bump stock legislation. Our only concern with that is the penalty provision. As it is right now, the law in Rhode Island is if you possess a pistol without a license, that is a 5-year felony. And to, as Mr. Sakosha said, to possess something that maybe apparently the bump stock is pretty innocuous unless it's mated up with a firearm, that the possession of it ought be a 5-year as opposed to a 10-year felony. Lastly, the Attorney General's Bill 2615. This was a bill that was introduced last year, at least on the House side, an identical piece of legislation, House Bill 5554. Our issue with that, again, is the issue of intent on the part of the person receiving the firearm, as well as, we've have consistently over the years have opposed mandatory minimums, and tying judges' hands in imposing sentences. This bill would prohibit the use of a suspended sentence, probation, or deferred sentences for those with 2 or more violations. One thing that I've learned in my years of practice is that criminal offenses can vary and have a rather rich set of facts and circumstances that are unique to that particular case. And absurd results can and do happen when you tie judges' hands when it comes to sentencing. So to be consistent, we think that provision ought not be in the bill. I'd be happy to answer any questions you might have.
Thank you. Any questions or comments for Mr. DeLauro? Thank you. Ms. Burke-Bryant, good evening and welcome.
Good evening, Madam Chairwoman and members of the committee. My name is Elizabeth Burke-Bryant, and I'm here today to voice the support of Rhode Island Kids Count for 4 of the bills before you this evening. First, I'd like to start with S-2289, which is sponsored by Senator Metz, co-sponsored by Senator Golden, Quesada, Crowley, and Calkin. This bill would provide that only peace officers be permitted to carry firearms or other weapons on school grounds. We are in support of this bill because we are concerned that Rhode Island is an outlier in this particular area where, according to the Giffords Law Center to Prevent Gun Violence, Rhode Island is only one of 8 states that allows concealed carry permit holders to carry firearms in K through 12 schools. We are concerned that teachers, principals, nurses, coaches, custodians, or anyone else with a permit to carry a concealed weapon can legally bring their gun on school grounds under current Rhode Island law. We are concerned that a weapon could accidentally or intentionally be accessed or fired by a student, teacher, or other school personnel, and think that the presence of guns in schools makes students less safe and increases the likelihood that tragedy could occur as the result of an accidental, intentional, or self-inflicted shooting. For these reasons, we urge you to bring Rhode Island in line with our neighbors, Massachusetts and Connecticut, and most other states in the country, and pass Senate Bill 2289 to keep guns out of schools. The next bill I would like to provide our support for is S-2492. That is the bill that would provide Superior Court with the authority to issue extreme risk protection orders when the court finds the subject of the order is in imminent danger to cause personal injury to self or others by having access to a firearm and requiring the individual identified in the order to surrender all firearms. This is one of the bills that is getting a lot of attention both in Rhode Island and nationally. While the Florida shooting has led to a heightened sense of urgency for a public policy response to gun violence, the issue of mental health issues and keeping guns out of the hands of people that have been determined as the subject of an extreme risk protection order is being considered by several states. The issue of gun violence hits home in Rhode Island. Our data shows that in Rhode Island between 2011 and 2015, there were 168 emergency department visits, 61 hospitalizations, and 12 deaths of children and youth under age 20 related to firearms. Senate Bill 2492 makes significant strides to strengthen public safety and identify opportunities to flag individuals who may be in need of intervention. Finally, we support S-2493. S-2493, which is sponsored by Senator Miller, which would restrict the use of ammunition feeding devices capable of holding more than 10 rounds of ammunition, as well as S-2292, which is the bill that is sponsored by Senator, I've just lost my place. Sorry about that. I'm sorry. 70 for sponsoring this bill, and we respectfully ask your support for this bill as well. We believe it's important in terms of preventing gun violence, and we urge your support for this bill. This is a kids and youth and families issue. We thank you for your attention tonight, and that concludes my testimony.
Thank you, Ms. Bryan. Are there any questions for this witness before we move on to Mr. O'Neill, I just want to say that I appreciate Mr. DeLauro's comments and the thoroughness of his analysis. Before we move on to any other testimony, I want to say that I really appreciate Mr. DeLauro's thorough analysis of the red flag bill. I signed as a co-sponsor, but there are issues with the standard. People have openly talked about how there are certain issues that will need to be tweaked with this bill before it's adjusted. And I think Mr. DeLauro's hit almost every one of them that I had in my mind. So anyway, any questions from Ms. Bryant? Mr. O'Neill?
Good evening, Senators. I'd like to start off with 2134, the crimes reporting. We're totally in favor of that. Our brother organization took 2014 data, and it showed that 75% of the gun charges were dropped. Also, back in 2013, Representative Chippendale on the House side studied 2010 and 11, came up with 95 percentile. And the reason why I mention that is that, and as you know, Joey Limbeck did mention that, you know, cases are pleaded down, but how many times does the same criminal get that same charge? If he's caught with a gun once, gonna caught with a gun twice, then give him 5 years and let him sit there. Let him learn his lesson. You know, it's the criminals, we're always asking for the criminals to pay a stiffer penalty when it comes to firearms. You know, that's the way it should be. You know, earlier, it just seems that there's a reluctance as far as going the full distance on convicting somebody with a gun charge. So
Michael,
I just wanted to say that.
Let me just jump in for 1 second. My concern with that, and the reason I put that bill in, is so that we, as an elected body on the House and the Senate side, are able to have those statistics annually in real time. And I'm just surprised again that the Attorney General's office, Joey's not here, but that there'd be a reluctance to do that, cloaked in statement that there's duplicity. For the life of me, I don't get that.
Yes, sir,
Wouldn't
I'm
you
in
want to
agreement.
come before the General Assembly annually and brief the General Assembly so that we all could look at it collectively and discern what the right way to go is? There's no argument that refutes that. Duplicity is a red herring, and I'm really taken aback by that, respectfully. But anyways, please go on.
I'm in total agreement with you, Senator. So I'll move on to 2148, reciprocity bill. Senator Jacone, I believe there's a sub-A in it. I haven't seen it yet, but that particular bill does need some work as far as contracts with other states. Ms. Wyman earlier made a comment that having other states, you know, come in and carry that, you know, don't have our same standards. Well, if you look at Vermont, New Hampshire, and Maine, they have what they call permitless carry. So that means anybody who is legally can own a firearm can carry in those 3 states. So there hasn't been, it's been a few years now, it hasn't been an uprise in firearm issues with law-abiding citizens that are carrying, you know, without a permit. So that's you know, a lot of people have that issue, but a lot of states that are open carry and permitless carry don't have that issue. There is no statistics saying that there's a more issue with more people carrying firearms. Frank covered the bump stock, so 2274 shotgun. Last year, the Attorney General testified, Joey Limbeck, that it was put in for Omar Little. Now, Omar Little is from The Wire. The Wire was a TV show on HBO, and I know this because it was a great show, and I watched all 6 seasons. So, but I don't understand why this bill is in, because if I walk down the street with a shotgun slung over my shoulder and the police confront me, I'm pretty sure 100% I'm going to get arrested, because I believe that's open carry. Regardless if it's a rifle, you can't open carry a pistol unless you're, you know, a Brinks person that's carrying for his job on the outside with a uniform. So this to me just is, this bill, the shotgun bill, is more of entrapment for the law-abiding citizen. 2276, the minor bill, conflicts with Chapter 20, where 15-year-olds can hunt by themselves. The magazine ban, you know, we have, it covers manufacturing, so then we lose jobs in Rhode Island because we do have manufacturers that do magazine bans, plus the 2 studies after 2004. The assault weapons ban expired from 1994. I know the mayor was like 2004 to 2014, but he was off for by a few years, but that's okay. And it has, the study showed that it had no implications of crime going up or down because of the magazine ban. Moving permits to the AG authority, totally against for a couple of reasons. One, that means you have one authority in the state of Rhode Island. And if carry concealed permit holders will tell you back when Attorney General Whitehouse was in office, you went down to get your permit, the application was green. You take it home, you take a month, you fill everything out, you go back. Next month it's pink. Oh, you have the wrong application. This month it's pink. So he basically refused to issue any permits the whole tenure that he was in. And that's what happens when you have one licensing authority. And the reason why Joey Limbeck mentioned that, you know, the Attorney General does issue the most permits is because the towns don't want a shall issue. They're refusing. You have East Providence, where I think they're on their 5th case from the Supreme Court that you have to issue, and they're still not issuing. We have a girl that belongs to our gun club in East Providence. Her ex-boyfriend was very abusive, beating upon beating upon beatings. Everything was reported to the police department. She went for a permit because she has 3 children. Went up to the Supreme Court. Supreme Court said, issue the permit. Of course, they come down and East Providence says, well, you know what? We're not going to give you a permit, but if you catch one more beating, then come back and talk to us, and then we'll think about issuing you a permit. I mean, it's a shall issue on the town side. And they don't want to follow the law. A lot of them do. There are towns that do issue, but the majority of them don't want to. And to me, it's to go under one authority is going to let one person make all the decisions. It's not going to go fair for the law-abiding citizen. And I feel that you could have a Massachusetts system, which the city and town issues the permit, but it goes to the Attorney General. They just look over the paperwork, make sure everything's okay, and then they send the ID down to the town, but it's the authority of the town that issues the permit. But the AG has everything collective in one system, so when you do get pulled over, they can tell every city and town if that person has a permit, because it's logged in there. So we should have one general system of a database, but we should have the town issuing, and then the AG issuing, and that's the way it should be. As far as the national background checks, I don't understand why law-abiding citizens are the only ones that are selected to the side that they're going to have to pay for that. No one else that has to get a national background check has to pay for that. I don't agree with that. The red flag, wow. So the red flag. We have a domestic violence bill that passed last year. There's huge problems with it. There's constitutional problems with it. You give up ownership upon a restraining order. You know, the Supreme Court knows about it. The judges know about it. That has to be squared away. And now we're going to put the red flag in, which is like 9 times more on steroids, as far as I'm concerned. And the one thing that really bothers me about the red flag and the domestic violence that passed, and I am pro-law enforcement, but if a law enforcement officer is red flagged, there's a provision in there for him to still have his firearm when it comes to work. And I'm sorry, if the police officer should be able to go to work, sit at a desk, no firearm. Same thing with a domestic violence. If his right to own a firearm is taken from him, he should not be allowed to carry his firearm at work. Because again, if he's that unsafe or he's red flagged, then again, he should be under the same restrictions. So that's all I'll talk about the red flag part of that. I hope I'm moving quick enough for you, Madam Chair.
You're doing okay.
All right,
I'd
thank
let you
you.
know if you weren't.
All right. 2606 needs to have a better description of really what they want to accomplish on that. So, school grounds. There's a lot of misinformation. Ms. Wyman said that there was only 4 states in the country that allow carry concealed permits holders from K to 12. and that's not correct. There's actually 11. It's actually shifting in the opposite direction. Out of the 39 that are left over, they do allow carrying on universities and colleges. So, you know, I hear a lot of different, you know, talk about restricting law-abiding citizens would carry concealed permit holders from our friends on the left. But my issue, even with Mayor Lorza, who has a tough job because Providence is probably the highest criminal rate in the state, is that neither Providence or our people on the left that are anti-firearm are coming up with any solution. There's no talk of a solution. And my solution is this: for the last 6 years, we've been saying more security. Now, I work at Logan Airport. Every 2 years, I get badged. I go through customs check. On our doors for entry, there's a biometric keypad. I have to scan my badge. I have to put my fingerprint on it. I have to put a code in it. It allows me to go through the door. If I don't make it through the door in 5 seconds, the alarm goes off. I have to reset that door, and I have to call the state police and say it was accidental, and they'll look at the film and say, okay, you're all set, Michael, continue on. This type of system can be put in schools. Every door could have this and have one entry point of entry into the school. You could have one person monitoring that system. If the fire alarm goes off, the system will allow all the doors to open up so the children can get out. If you set that door off, that camera is going to tell you exactly who did it. So there's also bulletproof glass. The NRA did a study. In Texas, you couldn't be allowed to carry on school grounds. They changed that. They actually took the NRA's SHIELD program, and it did the whole study of what schools need. They've done 162 districts where they've changed with bulletproof glass, training people that work in the schools, whether teachers or principals, making them marshals on their choice, not mandatory. And then they've also trained people that are into the marshal program, so they have law enforcement there also. So with a good lockdown system, you can accomplish the security that we need. Now, I understand funding. And you may laugh at this suggestion, but this is 2 suggestions I have. One is, for the next 2 years, I tried to figure out, there's 20, maybe 28 schools I allowed in each district, in each city and town. There could be more, there could be less. So around, say, 1,025 schools in the state of Rhode Island. And I'm not really accurate on this number, but I just want to throw this number that I could try and get something. So if each citizen in Rhode Island every year, say for a 4-year program, was taxed $250, that would raise $1 billion. It takes on an average, according to statistics I saw in Idaho, because they actually reinforce their schools, around 400,000. I put in 900,000 because of the biometric doors and the personnel to run everything. So that's 900,000 that we could spend on each school just by those 4 years. And I'll write a check now. Because to me, it's the best thing ever is to secure our schools instead of everybody thinks that the assault weapons ban is going to stop school shootings. And at the end of the day, whether it's an assault weapon that a person goes into school with or a .45, the parent is still grieving because that child is dead. They had a lady the other day tried to get into a school with an axe. If she had gone into a school with an axe, either way, people are going to get harmed or dead. So let's fortify our schools. After 9/11, we fortified the airports. I lost my friend Renee Newell. They fortified the airports. Now it's very hard. You'll see a shooter like in LA get as far as the TSA part of it. They can't get through that because everything off of that is just public area. And so it's a great system. So I don't understand why September 11th and then, since Sandy Hook, we're still not fortifying our schools. You know, we have 2 congressmen, 2 senators. I don't know why, especially with this president we have, why we're not looking for federal money to actually sit there and fortify our schools. You know, they're putting in legislation for assault weapons ban. How about we put a bill in federally to protect our schools? Now, there's a gentleman, and my heart goes out to him. His name was Andrew Pollock. His daughter, Meadow Pollock, was killed in Florida at the last shooting. He was in the White House, and he stated, you know, my daughter, and now I visit her at the cemetery. And he did say, after 9/11, they straightened out the problem security-wise. Why 5 years later we still haven't done it for Sandy Hook, and why aren't the schools fortified? He also was on the Fox News yesterday because he walked the whole Senate floor in the Senate to get the bills passed to outlaw bump stocks, but also to fortify the schools and train teachers and principals and allow more resource officers and fortify the schools in Florida. And he said that he's going to work on the House side, he's going to walk the floor until they pass that bill also. He's a very courageous man, you know, that just lost his daughter and realizes, just like I've been saying for the last 6 years, that, hey, you know what? We need to fortify our schools. You know, I'll give you a personal example, personal tragedy. When I was 15 years old, I woke up in the morning. I went to school at Slater in Pawtucket, and on my way to school, I said, you know, my parents were divorced. I said, I'm going to call my father and see if he can spend time and hang out for the weekend. And, you know, off to school I went. Well, 9 o'clock, I got pulled out of school. There was my mother, and she says, we have to go home. So I went home. There was a naval officer there because my father was active duty Navy at the time. And he was a Navy recruiter in Boston. It was his last day on the Thursday. They had a dinner for him. And him and a Marine would carport back and forth to Boston. And their car had broken down in the breakdown lane right at the 93-3 split. State trooper, this is 1979, so there's no cell phone. State trooper stopped by, see how they were doing. They said, okay, we need a tow truck. He says, all right, tow truck's on the way. I'll come back in a half hour and check on you. Tow truck driver is coming down 93. This guy passed the tow truck driver, he said around 80 or 90 miles an hour. As he came over the hill of the split, it was over. The guy was in the breakdown lane, killed my father and killed the Marine instantly. The state police said he was drunk, but at that time with the laws, they could not take him for a blood test. They could only take him to the hospital because he had injuries. They couldn't find out if he was legally drunk because the laws didn't provide that. Now, the Mothers Against Drunk Drivers, they changed that. They didn't go after the firearm. They didn't go after the car. They went after the driver. So let's not go after the firearm. Let's go after the mentally ill. Let's go after fortifying our schools. It's logic. So I don't understand why 6 years later, again, we're not dealing with fortifying our schools. I know it's about money, but again, look, the suggestion I just showed you, I'll gladly take the tax for the next 4 years. I have no issue with taking that and spending the money to fortify our schools. The last thing on this bill I'll explain to you is the gun-free zone portion of it. There was this video on last year. This gentleman's running through the town, very anxious. You could tell his urgency. He runs into this building, finds his loved one dead on the ground. Puts up a sign outside, gun-free zone. It's almost like a Groundhog Day where it repeats the day. Chevy Chase woke up every day, or Bill Murray, and he repeats the day and he knows what's going to happen. Again, the next day, he's running towards the building. Again, his loved one's still deceased. He puts up a bigger sign, gun-free zone, and so on. It went on for, so my point to the story is a gun-free zone where you take, no one can have a firearm in the gun-free zone is not going to work. It just endangers more lives. So on the mental health aspect of it, it's I was kind of confused because, you know, the two police chiefs were here, and I remember back in 2013 that we passed the mental health task force bill, and that was, if I don't know if everyone remembers, but Washington, D.C. Navy Yard, there was a mentally ill guy that was working there for a contractor, went and bought a firearm and went on and killed Navy personnel. Well, that individual was in Rhode Island before that, and he was working at the naval base in Rhode Island. And he was stopped from buying a firearm because of the mental issues he was having. So they, either local or state police did their job here and stopped him from buying a firearm, but they didn't put him in the NICS system. If they had put him in the NICS system, then the Washington, D.C. shooting never would have happened. So mental health task force bill, and then in 2014, the bill was passed where if someone is taken to the mental hospital against their will because they're worried about them hurting themselves, it goes into the NICS system. So I'm kind of confused at what the chief was saying. We have this in play. I don't understand why it's not being used. So that's just a question that I have that I don't understand why that's not really being applied at all when it comes to mental health right now in Rhode Island. It should be. I believe that's the way the law is. All right. So, there's a lot of, my last thing on the carry conceal bill for schools, I hear about, school teachers and principals being trained. Country of Israel. Every teacher carries. And it's an AK-47 strapped over their back, whether they're out at recess or whatever. In 20 years since they've implemented that, they've had 2 school shootings in 20 years. So a well-trained person, it will work. It will protect plus fortifying our schools. So, all right, I'll move on. I'm sorry, Madam Chair.
If you can continue
ma'am.
along, we haven't even
done.
scratched the surface yet.
Yes, ma'am, I understand. The assault weapons ban, I covered part of that, and that there's no finding of after 2 studies were done that the assault weapons ban will actually it won't do anything as far as crime is concerned. You have other things that you have drunk driving, you have drugs that kill more people, you have doctors that kill more people. There's so many other things that are way above firearm deaths. So, this last thing I'll state, and I'll be done, Madam Chair, is we must reject the idea that every time a law broken, society is guilty rather than the lawbreaker. It is time to restore the American precept that each individual is accountable for his actions. That's Ronald Reagan. So I am done. If I have any questions that you'd like me to answer,
Senator
I'd gladly
Metz.
answer.
Well, not a question. Mike, Mr. Neal, over the years, I appreciate you because even though we're on opposite sides many times, you always take time to listen. And you're very patient with it and how you also let me know about your side. So I appreciate you. And I think for all of us, for me, is not to lose sight because sometimes we really have the same objectives. The methods is what people that are fighting over. So the objective really for me is to protect kids and to protect rights. Now, the methods, how we get there, we can dispute that at all times, but sometimes when things get emotional, people lose sight of what we're really trying to accomplish. And so I do appreciate your patience. And for me, the neighborhood that I come from, I still live in my grandfather's house on the south side. So in the summertime, I can hear off in the distance the guns going off. Richard Rose, he's an assistant prosecutor in the federal courts. He used to come. I was in charge of security at the high school where I worked. As vice principal, I was in charge of security. And we would have an assembly, and he would have, by decades, he would play the New Orleans funeral music, and all the names would come up of all the kids that had been killed by gun violence. And then he would ask, after several decades, couple of decades, he would say to the kids in the auditorium, how many of you know a name that was on that list? And almost every hand would go up of someone that was killed by gun violence. So I listen to you, but it gets. I try not to get emotional. But one thing I do try to pride myself in listening to both sides, and you do the same thing. And I just want to say that many times we're on the opposite side, but I appreciate you and your professionalism and how you handle things when you come up here to advocate for for your people. But again, for me, is I don't want to lose sight of the objective. The objective is to protect kids and to protect rights. The methods is what we'll fuss over, but prayerfully, we'll get through that and we can accomplish the objectives that we all want. And so I appreciate you. That's what I wanted to say over
Thank you, Senator. That means a lot to me.
Senator Metz. And thank you. Any other questions or comments for these witnesses? Thank you. The next group of witnesses I'll call are Jennifer Boylan, Adam Bryan, and Audrey O'Donnell. Just so those members of the public that are here and the audience that are listening who may perhaps be in overflow rooms, what I plan to do next is somewhat unconventional for this committee, but based upon the sheer volume of persons that are here to testify and signed up to testify, as opposed to me going through the list and continuing to call out names of people who may or may not be in the room, I'm just going to start taking people by seats so that once you've completed your testimony, you can go out and let people who are either in the hallway or in another area waiting to come in and testify refill the seats to just try and keep things moving along as much as possible. So that's my plan, just so everybody's aware of what we're going to do going forward. So Jennifer, you can go ahead. Good evening and welcome.
Good evening. My name is Jennifer Boylan, and I'm here on behalf of the Rhode Island chapter of Moms Demand Action for Gun Sense in America. We're a national grassroots organization with chapters in 50 states, and today I'm also representing 5,000 members of moms that are here in Rhode Island. I joined this movement right after the Sandy Hook shooting. I'm a mom, I have kids, and that shooting affected me deeply. Prior to that, I had no knowledge of gun laws, no interest in activism or politics or anything. But Sandy Hook really changed everything for me. As a volunteer for moms, I have been working on ending gun violence through many horrific mass shootings. I've been through Orlando and Charleston and Vegas, and there's just too many to name. In the wake of this shooting in Parkland, I now have 17 more reasons to show up here in front of your committee and keep working on this issue. I'm here today to show support for the red flag bill, that's 2492. We know that prior to mass shootings, people often display red flags, signs that indicate something is wrong. They should not have firearms. We also know that the red flag bill has a suicide prevention component that we support. 2/3 of gun violence victims are suicide deaths with a firearm. So we support that for that reason. Most gun deaths are suicides. So this bill would have a great potential to reduce suicides. I do want to also mention another example of a mass shooting in which there were red flags that got a lot of press, and it was the 2014 shooting in California, Isla Vista. The shooter in that case displayed a number of warning signs. Many red flags went up. Homicidal threats, suicide threats, and his parents contacted law enforcement, but law enforcement was unable to do anything. 3 weeks later, this person used his weapons to kill many people, and in response to that, California passed their own version of a red flag law. I would like to pass to the clerk a petition that I have, and it has 1,272 signatures on it from concerned Rhode Islanders. That these signatures were gathered in the last couple weeks in support of this red flag bill. And I also would like to express support for the bump stock ban bills, as well as the bills that limit capacity for the magazines. There's a growing body of evidence that shows limiting capacity in the magazines will have a meaningful impact and will save lives. So in closing, I would like to say this. In the wake of Parkland, our children are really watching us. They're asking, what will we do to protect them and keep them safe? I'm asking, what will you do to protect them and keep them safe? Please don't throw up your hands and say there's no answers here, there's nothing we can do. There's plenty we can do. We don't want the next Parkland to happen here in Rhode Island. With your leadership, I hope that you will soon be able to tell our children that you did everything you could to keep them safe. Thank you.
Thank you. Any questions or comments for this witness? Thank you. Senator Nesselbush, I know you had something you wanted to say, and I apologize for making you wait this long.
No problem. Thank you, Madam Chair. I did want to say that this is my 8th year sitting on this committee, and I really want to go on record as being in favor of common sense, reasonable gun control. I know the devil is in the details, so to speak, but it seems that every year we sit here, the incidence of gun violence increases. And by that, I mean that it seems that almost monthly we suffer the outright slaughter of our people, including innocent children, parishioners who are worshiping in a church, concert goers, nightclub patrons. And against this plethora of gun violence, there seems to be a paucity of laws that are protecting our children and our families. And that's why I believe we have to act on a statewide level. I think both Frank and Mike, who are strong Second Amendment advocates, have left the room, but they tell me every day that Rhode Island does reasonably well in terms of our the amount of gun control we have in terms of comparisons to other states. And I'm glad about that, but in Rhode Island, we can and we must do better. I know there's a great deal of passion on both sides of this issue, and I especially want to thank the moms who are here tonight and the students, but obviously we know moms have many, many other obligations tonight. So thanks to all of you for coming out and engaging in what is truly a worthy debate. So I know that oftentimes one of the things I love about this building is that the committee chairs and the powers that be will try to have sides come together and air their differences and come out with something that both sides can agree on. And that will be great if it can be possible. But I'm also here to say that I believe that we as legislators cannot abdicate our responsibility to act. I believe we must do something to stop the slaughter of our own people. I've heard so many good ideas tonight. Most recently, Mike O'Neill was speaking about fortifying school security. So if it makes sense in passing common sense gun control, let's fortify the security in our schools and pass a red flag law, ban assault weapons and bump stocks and some of the other great ideas that we've had tonight. So I stand in solidarity with all of you who have come out tonight to voice your support of reasonable, common sense gun control. Thank you, Madam Chair.
Thank you. Good evening and welcome.
Donald. I am a sophomore at the Met High School, and it is a pleasure speaking with all of you today. I am able to reflect on the times as far back as elementary school, when I'd be tucked in a corner with peers, whispering about whether this lockdown may be a drill or not. What about my brother on the floor above me? Will he be okay? These are the thoughts that ran through my mind at the age of 6. Fast forward to 5th grade. I had been working with schoolmates as I heard the loudspeaker come on. I still vividly hear the shakiness in my principal's voice as we were notified that on Friday, December 12th, 2012, there had been a shooting at Sandy Hook Elementary School in Newtown, Connecticut. There I was at my desk, at the age of 10, yet again being struck with the thought, what if that were me? The idea of having to fear being shot in our classrooms has been instilled in our brains. The reality is, I still dwell over that same thought over 5 years later, as my friends and I are at a table discussing recent events, thinking, am I next? Enough is enough. Protect kids, not guns. As a student, I have heard from other youth organizers that this is what the youth communities want: to eliminate the fear of another shooting and to ban assault rifles in Rhode Island. Adults cannot expect youth to focus on doing well in school if their brains are fully occupied by the ways in which their basic needs of safety are not met. If youth can't function well in school due to their worries about survival, then how may our society truly advance? We are demanding for the passing of this bill for the ban on assault rifles in Rhode Island and weapons. These are issues that deserve attention. We are going to be heard. It's time that we speak up and stand up and bring the change we wish to see. I ask for your support to stand alongside us for the passing of this bill on the assault weapon ban. Thank you for your time.
Thank you so much for your testimony and for coming up here. And there's been a lot going on here this afternoon, so it's impressive that not only did you come, but you stayed to testify. Are there any questions or comments for this witness? Thanks.
Exams tomorrow morning?
No.
Good evening and welcome.
Good evening. My name is Ada Bryan, and I'm a freshman at Classical High School, and I'm here to testify in support of the Safe Schools Act. I'm not only here to speak for myself, I'm here to speak for a large group of high school students who strongly believe, as I do, that these laws are essential to protect not only the physical, but emotional safety of students across Rhode Island. Throughout my years in school, there has been a climate of fear. In elementary school, we were conditioned to protect ourselves and to fear for our lives, all while trying to learn our times tables. We were so conditioned as students and as teachers to fear firearms and to fear shooters that when one time a bell went off in the boiler room, we all went on lockdown for 3 hours. It seems ridiculous now that a harmless bell caused the 4th and 5th grade class to lock the doors and hide for 3 hours, but look at it this way. We had been taught that any bell, any ringing noise didn't mean that there may be something wrong in the boiler room. It meant someone was actively hunting us down with a gun. They made us sit in our cubbies with our knees tucked up to our chins, and they told us to cry quietly. That should never happen in a school. It never even occurred to me then that someone would be allowed by the law of our state, to have a gun inside of my school. How could someone who is not a fully trained peace officer be allowed, legally given permission to enter a place full of young children holding a dangerous firearm? We are one of only 4 states that allow that to happen. My 3rd grade self saw Sandy Hook on the news. I feared shooters and I feared for my life. But those fears always came from outside of the school. We could lock the big metal doors at the front, and the big scary people with guns couldn't get to us. Please vote to pass the Safe Schools Act to make that true. 83% of Rhode Islanders like me believe this should be passed. Please listen to the voices of students who will be the ones in the schools with the guns. I will say plainly, I would not feel safe. I would fear school if there were guns inside. Keeping guns, besides those carried by peace officers, out of my school is the way I and other students would feel fully safe. I urge you to vote in favor of this bill. Thank you.
Thank you. Senator Coyne.
Well, I want to thank you very much for coming up here to testify. You're very brave, very poised, very articulate. And I still have, I have 4 children. I'm a mom, and I have a daughter who is a freshman in high school. So I hate to think that she feels the same way as you. They go through these drills, but you're a new voice. You're a new voice to this movement, and people are listening. Before I became state senator, I was on the Barrington Town Council. And anytime a kid would come up with a project and try to promote that project, we always stood behind them because it was a different voice. It was new, refreshing, but we can tell how serious this situation is when our own children have to come before us to make a statement like you are today. So thank you.
Thank you.
Any other questions or comments for these witnesses? Thank you. So as I said, I'm going to do my best to get everybody up that is looking to testify so we can kind of refill in the seats with those who are waiting out in the hallway. So Stacia, if you don't mind coming up. I'm sorry? Sure. Sir, you can come up. Maybe are there 3 in your row that are looking to testify? If you could just come up. Okay. So just to be clear, is there anyone else in this room that is looking to testify, so I'm clear? Okay, why don't we have you two in this row right here who raised your hand, the second row. You, sir, and sir, you with the glasses on your head. And just to be clear, my intent is, because this is on TV and that there are other areas, even in the building, that you can watch, I'd like to get those people who want to come and testify, be able to come and sit if they're standing out in the hallway. So, sir, we'll start with you. If you could just identify yourself, each of you, before you go, since I'm not going off the list. I just have a feeling that there'll be probably hundreds of names of people that are either gone or won't be able to come up, so I don't want to make everybody wait while I read through a roll of names. Sir, good evening and welcome.
Thank you, Madam Chairperson and Senators. I was glad you allowed me to go first because I got here at 12 o'clock to sign up, so I appreciate it. My name is Joseph Varon. I'm from Smithfield. I'm a 67-year resident of the state and a life member of Wallem Lake Rod and Gun Club. I'm not here representing the club. There are 150 or so people out there that'll be more than happy to do that. My problem with all of this is that we've heard the term assault weapon thrown around like it's a specific weapon, and it's not. It's just another gun. And the reason I say that is if you look at the assault weapons ban that's being proposed, it has a list of firearms in it, and one of the firearms that's not included in that list is a Ruger Mini 14. Now, I'm going to have a lot of my yellow-shirted friends here saying, what are you doing? Tell them about a gun. It's not on the list. It is exactly the same gun as an AR-15, but because it has a wooden stock, it's not an evil gun. It doesn't have a military look, but it can do just as much damage as an AR-15 can. So this whole assault weapons term is just, it's been perverted into being a scary term. And since that doesn't seem to be working very well, we've now grabbed the term weapons of war. Well, I would submit to you that a shotgun is a weapon of war since many military people carry shotguns. They also carry hatchets. Are those weapons of war? But I'm not going to go any further on that. I just believe that banning an assault weapon is not the solution. You've all elaborated on how the solution is security and the safety of our children. And as a gun owner, I agree with that. As far as high-capacity magazines are concerned, where did the number 10 come from? Can anybody answer that? Because it seems like it was just an arbitrary number pulled out of the sky. Frank Sakosha very eloquently elaborated on his 13-round magazine. I have several firearms that the standard magazine was either 13 or 15. Is 3 or 5 rounds really going to make a difference? No. It can be, like Frank said, instead of carrying 1 mag, he carries 2. He's in effect carrying more ammunition. So I think maybe looking at high-capacity magazines with a little different view as to what is really a high-capacity magazine. I don't own a 100-round drum magazine. I don't see the useful purpose for it. Some of my friends here in yellow shirts would probably argue with me on that too. If you do ban these magazines, you're forcing me to get rid of a bunch of magazines and replace them with 10-round magazines, and that's a monetary cost that a lot of people in the state don't need to go through, and they're voters in this state. With regard to firearms being used by youth, there's a lot of kids in this state that enjoy the hunting and shooting sports, and to restrict their access to guns it's again not going to do anything for safety, and safety is where we really have the problem. The Providence Journal reported that Rhode Island's crime rate is continuing to decline. Well, if we don't have a gun ban, what is causing that? It's something else. There's something else going on, and it's a very positive move. According to the FBI Uniform Crime Report, Table 12 of 2016, 2017 is not available yet. In this state, there were 29 killings in that year. 0 with rifles, 5 with handguns, 7 of unknown weapon type, and 17 with knives, clubs, and fists. When are we going to ban those? Again, it doesn't help. But all of that aside, what really has happened here is the unthinkable. And the unthinkable is the fact that we had a social services group in Florida that failed to report an individual with obvious problems. He slit his wrists, and nobody thought he was a risk. The police visited this guy several times. As this talk, you know, he had number 39, 23. It was more than once. And they thought he was a problem, but not enough of a problem to keep him from getting a firearm. The FBI had credible reports that this guy was going to shoot up a school, and they did nothing. They did nothing. Was that unthinkable? I don't think so, because you can answer that for yourselves, but when Madonna publicly announced she thought a lot about blowing up the White House, did she get a visit from the FBI? I don't know. As a general aviation pilot, and I'm wearing my jacket, we discuss accident analysis fairly frequently. And the one thing we talk about is the accident chain of events. It's a sequence of events that if any one of them were broken, the accident would not happen. In Parkland, that's exactly what happened. You had an accident chain of events that was not broken. Had it been, 17 kids would not be dead today. And I think that's what's really important, that we have to protect these kids. Everybody's in agreement with that. The people with the moms that demand action, they agree with it. The people here wearing yellow shirts, we all agree with it. We don't want to see kids hurt. So keep this in mind and ask yourself, of all the mass killings that you're aware of, what was the one thing they all had in common? Was it an AR-15? No. Was it a handgun with a 13-round magazine? No. It was a mentally ill individual that should have never had a firearm in the first place. That is the focus of the problem. You fix that problem, you fix 99% of this problem. Get the mental health records into the NICS system, improve the background check system, fix the real problem, fix the system that's failed. Ban bump stocks if you want to, and I'm going to get criticism for this too. I don't care, because they shouldn't have been legal in the first place. That was an Obama-era screw-up with BATF. It should not have been legal. You've got to break the accident chain, because banning firearms, certain magazines, or even raising the legal age to buy a rifle isn't going to stop somebody intent on killing from driving a Ford F-350 with a snowplow through the Bristol 4th of July parade, killing hundreds in seconds. We've heard again about the AR-15, that it's such a weapon of war, such a weapon of mass killing. I would submit to you that if a nutcase were able to get into this door right now with a shotgun, he could take out that whole panel with 3 shots. Think about that. Banning the assault weapon, so-called, is not the answer. Banning high-capacity magazines, I really think you need to revisit the definition of what that might be. Certainly belt feeds, I think that pretty much qualifies. But 15 rounds, 13 rounds, even 20 rounds is not going to make the difference. So I urge you all to reconsider that. That's pretty much what I have to say. I've submitted this in you have copies. Please excuse all the markups on it.
Thank you. We appreciate your time and the fact that you've been here since noon. Thank you. Are there any questions or comments for this witness? Thank you. Sir, good evening and welcome.
Good evening, Senators. My name is Sven Soderberg. I am the co-owner and operator of Elite Indoor Gun Range in Peacedale Shooting Preserve. I am also a veteran of the Rhode Island National Guard as an infantryman and a combat wounded veteran of the war in Afghanistan. I also have taught thousands of people firearms safety, firearms handling, safe shooting practices, had Q&As with many people about firearms laws in the state. While I would like to thank all of you for considering common sense gun laws, I do have to criticize what I've heard tonight, because it's been wrought with a blind eye for statistics, for evidence. There's been a seeming lack of common sense going on in this entire process. I'm not going to sit up here and parade kids in front of you. I'm not going to sit up here and make this cute. I am going to speak to some things I've heard this evening regarding Senator Metz and your reference towards losing a firefight between a handgun and a rifle. I don't think that's a cut and dry case. And if you told me I had to stand up to a shooter who had an AR-15